Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, January 29th, 2025. We have 9 bills on the docket. We're going to start off with Senator Hester with Senate Bill 360, and then we're going to go on to Senator Hester again for Senate Bill 362. Senator Hester, welcome.
I have a couple of individuals on my panel. Should they come up?
Of course, yes, please.
Good afternoon, Mr. Chair, Vice Chair, members of the committee. Thank you for your consideration of Senate Bill 360, which provides civil remedies for victims and creates a misdemeanor for those who distribute a computer-generated visual representation that falsely depicts a person in a sexual manner. Last year, you heard and passed a bill out of the Senate with unanimous favorable report. However, with slight differences between the Senate and the House versions, we ran out of time to get the bill over the finish line. This year, we've strengthened the bill with some changes to address the concerns in the House. Just for those of you who weren't here last year, the issue is that as websites and apps that use artificial intelligence to generate sexual imagery have grown in popularity since their inception, and if we look just at the first half of 2024, AI-powered undressing websites, which create non-consensual nude images, collectively garnered over 200 million visits. The ease of access to these websites is facilitating the proliferation of fake imagery that is devastating the lives of an ever-increasing number of victims. On a national level, the U.S. Senate has taken action by unanimously passing the Disrupt Explicit Forged Images and Non-Consensual Edits, the Defiance Act of 2024. Unfortunately, this has stalled in the House in July. So building on these efforts at the state level, SB 360 introduces strong state-level protections, offering a critical pathway to justice if the federal bill fails, and reinforcing enforcement measures should it succeed. So specifically, Senate Bill 360 will broaden the existing criminal and civil code by doing a few things. First, it amends the existing misdemeanor revenge porn offense to apply to the distribution of explicit computer-generated media under circumstances in which the possessor did not have content and had intent to harm, harass, intimidate, or coerce. Second, it enables the victims to seek civil remedies through a private rate of action. Third, it enables further victim protections by restricting the availability of court-documented imagery from being viewed publicly. And fourth, it addresses the concerns raised during the 2024 session by removing the requirement for a victim of these offenses to have had a reasonable expectation of privacy in order to seek justice against the distributors. I want to mention that in my testimony, we've included a 2-pager of just anecdotes from all over the United States of what is happening to these victims. So that's there, should you choose to read it. But in closing, the rise of this non-consensual, artificially generated sexual imagery is only going to get worse as technology becomes more advanced and accessible to the average person. Now, this bill won't end that non-consensual computer-generated pornography, but it will definitely strengthen the protections for victims and addresses the risks posed by these new technologies and ensures that the state can hold perpetrators accountable. For these reasons, I'd like to respectfully request a favorable report on Senate Bill 360 and turn it over to my esteemed panel.
Thank you so much, Senator. Mr. Chair, Mr. Vice Chair, members of the committee, I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. This is actually my first time before the committee this session, so I appreciate being here. The Maryland Coalition Against Sexual Assault is the sexual assault coalition of all of the rape crisis centers who serve your constituents in your communities. Welcome to our 2 new senators. We are here in support of Senate Bill 360. Thank you for passing it last year. I wanted to just highlight a couple of issues to the committee. One is just the idea of harm. This came up more on the House side, but I want to be sure that you understand from the perspective of the survivors in these cases, there really is no difference in the harm experience between an actual image or a computer-generated image. Their parents seeing these images don't know if this is computer generated or not. A possible future employer, a possible future romantic partner. These survivors, they're humiliated, they are really traumatized. We've seen even instances of suicide after these images are published. So please keep that in mind. The other issue that I wanted to bring to your attention is last year the bill came over from the House with a different, so actual images were in one part of the criminal law and then fake images were in a different part. This creates the uncomfortable situation where if you have a defendant who's caught dead to rights with the image, their defense is going to be, oh, that was computer generated, so I should fall under the other law that's weaker. And that puts then the survivor in the position of having to testify about wrinkles and moles and very intimate issues with their own physicality that we don't want to happen. Therefore, MCASA strongly urges this committee to include a civil action in the criminal law as well. You do this in other parts of the criminal law, but that would give you more flexibility. I'm happy to answer the questions regarding the civil issues raised by the Public Defender's Office, but I am out of time, and we respectfully request a favorable report.
Good afternoon, Mr. Chair, Mr. Vice Chair, distinguished committee members. My name is Joyce King. I am Chief Counsel at the Frederick County State's Attorney's Office, and I am here on behalf of the Maryland State's Attorneys Association in support of SB 360. I co-chair the MSAA Special Victims Subcommittee, and we have unanimous support for this legislation. As my distinguished colleague stated, this fills a necessary gap in our legislation. The current statute does not define visual representation or quote unquote another identifiable person. So under the current statute, the state has to prove that the image, the whole person is identified or known. So the loophole is that if the person's identifiable face is in the photograph, however, it's paired with an unidentifiable body, this is a gap of the law and we are unable to investigate and prosecute these crimes. I've run our cybercrimes task force since 2019, and I've seen firsthand the proliferation of these types of crimes, the rapid development of technology, and the explosion of explicit sexual websites where these victims are being victimized by hundreds and thousands of people at a time. Every time an image is viewed, these survivors are being victimized. Sadly, we tried to pull the number of statistics of how many cases we could not proceed on, and sadly, the cases that we were identified had to be expunged because we were unable to prosecute them. Even more sadly is a lot of these cases are not even coming to the state's attorney's offices because these individuals, these survivors, are being turned away by police when they are being reported because they know it is not currently a crime. Revenge pornography is one of the most abusive tactics and most common tactics being used of power and control dynamics in intimate partner violence, in sexual violence. There's studies that show that 71% of victims have had a previous romantic partner post a nude on the internet. I did have testimony from last year that I can elaborate on a personal experience of a survivor, and I can also address the concerns of the public defender regarding these definitions during the question time, since I'm also out of time.
Excellent. Thank you all very much. Questions from the committee? Senator Love and Senator Sidnor.
Thank you, Mr. Chair. I just wanted to ask that question and give you the opportunity to address the opposition.
Thank you, Senator Love. So one of the things that the public defender raised is regarding civil action. So if I can address that, they suggest that Maryland law already permits civil actions for defamation, intentional infliction of emotional distress, and false light. This committee, however, wisely made the offense of a deep fake defamation per se. Right, and so that is different. Defamation, false light, IIED, all of those things require proof of harm. If something is per se, if you remember back to law school, you don't have to prove that harm, right? So that is a wise public policy that we encourage you to continue to pursue. Again, certainly we'd be happy if you wanted to add that per se in the criminal portion, where we are also suggesting adding a civil cause of action. But I would also say say IIED in particular, the intentional infliction of emotional distress, it's very difficult to prove that. So I do think that it's helpful to have that additional specific action in the criminal statute, and you have that in other parts of the code. So we encourage you to be consistent in this part of the code and add the civil action there.
Did you want to address the criminal?
I think you.
And with regards to the criminal section, I believe the public defender raised questions about the definition, computer generated as well as drawings. I mean, this is well established. Well, I mean, this type of language has existed in our current statute, and we have not had issues regarding that. Specifically with regards to computer generated, that anything could be computer generated. But I think it's important to note that the consent needs to be created without the consent of the person. So if somebody's agreeing to a filter or changing the contrast, while that is computer generated, that is understandably consented to. And that's with regards to the definitions.
This question is for Ms. King. Given what you were just saying, because I was curious about the computer-generated visual representation and the word drawings as well. Could a drawing be included in the, how we think of a computer-generated visual representation, and what we need? So and what I'm thinking about, I have my daughter. She's in school and she loves to get on her computer, and she has a pen and she draws. That I would think could be included within the definition of computer-generated visual representation. And with the way that computers are nowadays, you could draw and it would be indistinguishable from an actual visual representation. So I'm wondering if that needs further clarification so that those kinds of questions later on aren't raised if you're attempting to prosecute something like this.
If I understand your question, I think you're asking if someone's utilizing the drawing tool on a computer, is that somehow a gap in these definitions? Is that your question? And I would say not. Just because someone is drawing using computer generated doesn't make it exempt from this. I think the important part of the definition to focus on here is that it needs to be indistinguishable from an actual representation of the person. So if it's a cartoon drawing, and I think this language is mimicked off of many state statutes to overcome any constitutional claims, is that the point of this are deep fakes. It's not any artistic expressions or cartoon tools. I mean, it's if you are using computer generation to make it an indistinguishable image from a real image, if that answers your question.
Okay, then the distinction between drawings and cartoons, how would you make that? How would you draw that distinction?
This is, I mean, I think it's unnecessary to make that distinction because the point is that it's not included within the crime. So we're only looking at images that are indistinguishable from an actual person. And this actual exact language is replicated from the existing child pornography statute, which is passed constitutional muster for that. And I think it was included for that reason.
And again, I'm not questioning any of that. I'm just trying to think ahead and arguments that may be made that could be problematic. So trying to make certain that we're as clear as what we should be and not causing you any issues as you're trying to address these issues. So thank you.
Thank you.
Thank you, Mr. Chair. Ms. King, if you could come back up, please. So I want to thank you for bringing the bill back, Senator. I think this is an important kind of sometimes minimized, but an important overlooked issue. And I know that the specific case, if you could share that with the committee, I think it's important to hear how it affected this person.
Yes, I do have a survivor statement. So I'm not going to identify her by name, but in the summer of 2023, she did want to relay the horror, humiliation, and heartbreak. It was brought to her attention that a former friend of hers, had used her images off of Facebook, manipulated them using AI, and posted them on a sexual website, and she had no idea. By the time that she found out, her images and that website had been viewed thousands of times. He had used her face from real photos that she'd posed for, edited them extremely, and made them pornographic, engaging in all manners of sex acts. And what is more frightening is that in a lot of the cases that we see, when they post these on sexual websites, they're using real names, real locations. So not only is there an emotional harm to these victims, there's a real public safety risk of real danger that these survivors are going to be contacted, sought after by individuals on these illicit websites. So she wanted to relay that this happened to her. She did she sought out a restraining order, she filed criminal charges, and her charges, unfortunately, as we stated, were not, we were unable to pursue them because there was no crime.
Thank you.
Additional questions for this panel from the committee? All right, Senator, thank you all very much. Thank you. So that'll conclude the testimony for the proponents of the bill. We'll now switch over to the opposition panel. And joining us virtually, okay, Jeremy Zacher is not here from OPD. Is anyone from the Office of Public Defender here to testify in opposition of that bill? Okay. All right, with that, that'll end the hearing for Senate Bill 360. Senator Hester, welcome back for Senate Bill 362. You can bring up your panel. Do you have a sponsor panel you'd like to bring up?
Mr. Chair, it's a bit hard to hear in the back of the room.
Can you all hear me now? Can you hear this? No? Kind of? In the back, they've got thumbs up. Okay, excellent.
Chair Smith, Vice Chair Waldstreicher, members of the Judicial Proceedings Committee, for the record, Senator Katie Fry-Hester here again to present on Senate Bill 362, Forged Digital Likeness, Distribution, and Prohibition. This legislation addresses the increasing misuse of artificial intelligence to create forged digital likenesses, realistic representations of individuals that are indistinguishable from the authentic ones, but falsely presented as genuine. These deceptive creations not only mislead viewers, but also leave the targeted individuals unaware and defenseless against such violations. The consequences can be devastating, with the potential to cause irreparable harm to reputations and inflict significant personal damages. Earlier last year, a troubling incident in Pikesville High School highlighted the urgency and the threat of this issue. As reported in the papers, the school's athletic director used artificial intelligence to create a false audio recording of the school's principal, leading the public to believe he had made racist and anti-Semitic remarks. This falsified audio, while not technically advanced, required only a basic recording of the principal's voice and a $5 a month artificial intelligence tool. The incident served as an important warning and a call to action. Anyone with minimal resources can now use AI to forge somebody's likeness. In the aftermath of the Pikesville incident, Senator Hettleman and I recognized that there was a critical gap in our legal framework, the need to hold individuals accountable for creating synthetic media with the intent to deceive. As you know, there are certain forms of speech, such as fraud and obscenity, that fall outside the protections of the First Amendment. Therefore, we sought an Attorney General's opinion on whether deepfakes deliberately crafted to deceive were protected. The opinion confirmed that the language in this bill would likely pass First Amendment scrutiny by a reviewing court to the extent that it covers only fraudulent speech and/or content. And you should have a copy of that AG's letter in your bill file. So Senate Bill 362 will protect our citizens from this emerging threat and strengthen Maryland's criminal law by doing three things. First, it defines a forged digital likeness as any computer-generated visual representation or audio that is indistinguishable from a genuine representation, misrepresents an individual, and is likely that a reasonable person would believe that it was genuine. Secondly, the bill prohibits malicious distribution by making it illegal to knowingly share a forged digital likeness as if it was genuine, when the person sharing knows that or should reasonably know that the image was fake. Third, it provides legal protection for people who clearly mark their content as fake or ensure that viewers understand their content is not real, clarifying that this bill may not be misconstrued in a manner that infringes on the right of free speech or of the press, and clarifying the bill does not apply to works of art. This legislation will provide Marylanders protection against the growing misuse of AI and prevent the weaponization of digital likeness for malicious purposes. As our technology gets more advanced and these forgeries become more common, it is more important now than ever that we are equipped with a pathway for victims to receive justice. Fundamentally, every person should have a right to their own likeness. I would like to note that we have been working with the Office of the State Prosecutor on a bill that provides a different legislative vehicle to reach the same goal. This bill would define the creation of deceptive deepfakes as a form of identity fraud. We don't yet have this bill back from drafting, but we're looking forward to collaborating with the chair and members of this committee to reach consensus on the best path forward. In addition to the Attorney General's opinion, I've also submitted a list of instances from across the United States of where these deepfakes have caused harm. And with that, I would like to request your favorable report and turn it over to my distinguished panel, starting with Scott Schellenberger.
Good morning. I know it's been a while since you've seen me. So Scott Schellenberger, State's Attorney for Baltimore County, here in support of Senate Bill 362. So what if you're a county executive, a police chief, or say, a state senator, and you have someone who has a terrible grudge against you, and they're so angry they decide they're going to get back at you. And then say you're somebody who maybe has thousands of hours of audio recordings out there with your voice on it, and that they have the ability to manipulate what you're saying and release it to the public. And say that it angers people so much that the police have to sit in front of your house for a couple weeks until things die down. Well, that scenario is not fictional. That is what happened in my county. And I cannot go into great detail about the case because the trial is still pending. In fact, it was scheduled yesterday and it was postponed for later on. But after the incident in Pikesville, I did what any good prosecutor is going to do. I pulled out this book, the criminal laws of the state of Maryland. And I started looking through this book, the table of contents, the glossary, and everything. And I could not find anything that really applied in that Pikesville case. And that's why we need Senate Bill 362. We have to fill a gap that existed. The only thing that we could find that had to do with that recording was disrupting school activities, which carries a whopping 6-month sentence. We need to do more, and we need to keep our laws in line with our technology. I am aware that there are other forms of laws that can come along, and I'm happy, as always, to work with whoever wants to put these together. The reason I like this one so much is it's simple, it's to the point, and it's easy to understand. It clearly defines visual representation or audio recording, and it clearly says what I have to prove in order to convict someone. And we only ask at the moment for a modest maximum sentence of 3 years. It's a starting place. But this is a very good law, but I'm happy to work with the other one and get everything in one place. Thank you.
Chair Smith, Vice Chair Waldstreicher, and members of the committee. My name is Ben Yellen. I am the Program Director for Public Policy and External Affairs at the University of Maryland Center for Health and Homeland Security. After the horrific incident in Pikesville, we were in contact with Senators Hester and Hettleman to try and devise a legislative solution to this very difficult, vexing problem. We have done legal research for Senator Hester in the past on issues ranging from artificial intelligence to cybersecurity. And the bill before you, Senate Bill 362, is the result of that collaboration. In our view, this bill balances the need to disincentivize the type of bad behavior at issue here while preserving robust First Amendment protection for constitutionally protected speech and technological progress. For centuries, the law has criminalized acts that deceive the public by some deception against which common prudence cannot guard. In the pre-digital world, this philosophy was reflected in bans against forgery, defined as the act of fraudulently making a false document or altering a real one to be used as if genuine. Just like with forgery, it is not just the person directly affected by the deepfake that is victimized by forged digital speech, but society itself, because such fakes undermine the basic trust individuals have in the testimony of their fellow citizens in nearly all contexts. This bill does not criminalize constitutionally protected speech. As mentioned by the sponsor, artwork, drawings, paintings, cartoons, and other works of art are exempted. Any digital media being distributed which is not being presented as if genuine, but for some other purpose, such as parody or satire, is not criminalized here. Finally, a person could only be held criminally liable if they know or have reason to know that the media is a deceptive deepfake. As a free society, we must protect free speech. It is our view that deceptive deepfakes, such as the one in the Pikesville case, cannot fairly be considered speech, and respectfully, we request a favorable report on Senate Bill 362.
Good morning. My name is Christopher Webster, and I am the Program Director of Cybersecurity and Emerging Technology at the University of Maryland Center for Health and Homeland Security, and I worked on this with my colleague Ben Yellen, who just testified. I want to use my time to highlight 3 key points I think are critical to understand why we support this approach. First, it doesn't target the generation. It doesn't criminalize actions that a computer might take in a basement all by itself. It targets the distribution by humans and the presentation as if genuine. Second, this approach is not centered on the harm it causes to the person portrayed. This isn't accidental, this is purposeful. The reason is that we believe, like forgery and counterfeiting, the harm here is the harm done to society. It's the same or similar harm that a counterfeit $20 bill does to our monetary system. To bring that out a little more, I want to clarify that this would criminalize deepfakes that you create of yourself, your favorite political candidate or athlete, if those meet the definition of being indistinguishable and you present them as if genuine. In those situations, a prosecutor would not be able to show harm to a specific individual because the harm there done is to the marketplace of ideas. It's in fact harm to the system that the First Amendment seeks to protect. And finally, I want to make the point that this is narrow. This won't cover special effects in your favorite Marvel movie because the context there is a tip-off to anybody of reasonable deliberation that what they're seeing is fake. But it would cover deepfakes in a documentary film that featured fake video footage and things of that nature. Accidentally sharing is not criminalized by this bill. It's cropping out a warning label and resharing would be. And on the note of warning labels, a simple warning either in context or somewhere on the image saying this was generated with AI tools is sufficient to avoid any prosecution. That's why we're in favor of it. Thank you very much.
Thank you, Mr. Chair, and thank you all. Thank you, Senator Hester, for bringing this bill. Would this cover the telephone scams that we're hearing about where a grandparent is being called and they hear their grandchild's voice? Please, I've been arrested, my attorney needs $10,000, that sort of thing. I understand you could probably get them under extortion, but would this cover that generation of that grandchild's voice?
Yes, I believe it would, and as I've testified in the past on other bills, I'm very concerned about that, particularly when it comes to elderly abuse. and the example that you gave with regard to a grandfather. And so I believe that you could use this bill, this statute also, to take care of that situation.
Got it. Thank you. Thank you, Mr. Chair.
Thank you. For the last speaker, you gave a description as to why the bill was crafted as it was. I think both of you from the same agency kind of kept talking about forgery. But in forgery, I believe that the actual act of creating a forged document, that's criminal, correct? Under this legislation, if I create this digital likeness, I don't think I've broken the law unless I've then distributed it. So what I'm trying to understand is why we focus on the distribution rather than the creation.
That is right. I thank you for highlighting that, because that decision was a purposeful one. There's two basic reasons. One, we want to make sure that we make this as consistent with our convictions about having strong First Amendment rights as we possibly can. And we don't want to accidentally criminalize behavior that doesn't have a harm to society. Creating something in a research lab or a training facility that is not distributed, we don't believe that causes the type of harm to society that you would prevent. The second reason is we want to target not only the initial distribution, but the very prevalent redistribution that takes place on social media. We would like to be able to make it criminal to reshare something over and over that you know is not genuine. And so we focus on the distribution.
How do you know? I mean, because when the incident happened at Pikesville last year, that recording was distributed throughout. And I can remember the conversations of people listening, making their judgments because they had relationships with this particular principal, and sharing with me, they felt like that was something that he probably did say. And it continued being distributed. Obviously, under this bill, because they did not know or reasonably know that it was forged, they shouldn't be. It wouldn't be. That wouldn't be criminal. So how do you know? I mean, this is an issue.
It is an issue.
And I attempted to. And talked with the prosecutor about trying to figure something out. But for the life, I couldn't figure out something that I thought would work, and I left it aside. So again, I'm grateful that you all have tried to come up with something, but I'm just trying to figure out how this will work.
Sure. So just to clarify, if we use the Pikesville example, this bill would criminalize the initial distribution by the person who was ultimately charged, because that person obviously knew that the generation of that audio was false, so he had the required criminal state of mind. This would not criminalize those who did not realize that the audio was false. And obviously that was purposeful, and I think courts are well situated to observe the intent when one is distributing, if they're recognizing that it's genuine.
So it's now published, everyone knows that the thing was fake. This would now criminalize anybody else from redistributing it now.
If they were distributing it as if genuine, meaning that if they were distributing it for another purpose, which we've tried to carve out in the text of this legislation, for some type of artistic purpose or for expression, for some type of academic discussion, that would not be criminalized. It's the act of presenting something as if it were genuine. So I think that's covered in the mens rea requirement in the bill. But that's also something I think all of us would be happy to work with the committee on in resolving that issue.
Thank you.
Thank you. I just want to compliment all of you, whether I agree with every word of this bill or not. I just appreciate the caliber of the work you did ahead of time. I appreciate the citations and research you did, and then the caliber of your testimony. Just a couple of quick questions. I take it that you in some ways you patterned it after, passing, fake money, in the sense that somebody would have to create the money, and so they know it's fake, and then pass it on, representing it as authentic money, and no one else would be caught up in that criminality if they didn't reasonably know, which none of us would know. I would not have no idea unless it said fake money, maybe, right? So is that what you did? Did you pattern it and incorporate longstanding principles in other areas of the law? Thinking about forgery, thinking about, I forget the word for when you make fake money, but in your
Counterfeit.
Counterfeiting, yeah. Is that where we got some of the language or a lot of the language and themes
Yes,
in the bill?
that was where it came from, and that was the intent.
Right,
Was that the person had to know. Remember, it said,
Right.
The key is the state must prove that it's likely to deceive a reasonable person, and that it was created to imitate how the person looks or sounds. And so we have to prove all of those things.
Right.
And so we think that there are enough protections in here to make this not only a law that fills a gap, but also one that is reasonable, so that those other people that Sidner was concerned about would not be prosecuted because they had no knowledge.
Or no reasonable way to know.
No reasonable way to know.
And then I don't know if this was talked about, but is this a first in the nation kind of bill, or are we modeling it from other, states, and just curious?
So after the incident happened and after I did my book search, I did a national search, and I did find a statute in another state, but it was very complicated, and I decided that we have some very smart people who can kind of start from the beginning. And again, that's why I kind of like this as a standalone, because it's important. But now I believe other states have tried. I don't know the numbers, so I'll defer.
Yeah, thank you for the question, Senator. So in terms of deep fake, pornography, revenge porn, deep fakes used in elections, all of those, there's, I can send you a link to a website. At least 25, 30 states have done stuff specifically on each of those issues.
Okay.
In terms of going broader to try to catch other things, I think there's one other state that has tried something like this, making it not forgery, but identity theft. And I can get that information to you as well. I think what's interesting is we really started off aware of the First Amendment possibilities, because there's so many broad deepfake bills that have been struck down. And so we sought the AG's opinion first. And if you look at page 2 and the first kind of 2 or 3 paragraphs, that's really where the AG is suggesting that, fraud and forgeries are not protected by First Amendment, and that's how we should work in the bill.
No, I really respect and appreciate that, because the more you align yourself with existing laws, existing principles, existing balances between First Amendment and other incidences that have some similarity to this current ability through technology, the safer ground you're on for not only meeting any challenge, but also fairly criminalizing that which should be criminal and that which should not be, to protect innocent people. So that would be very helpful if you follow up, and thank you very much.
Of course, and we have a very good drafter who may or may not be sitting in the room. Thank you so much.
Also quickly, there's a proposed federal statute sponsored, the primary sponsor is Senator Ted Cruz of Texas, but there are bipartisan co-sponsors. It has to do with images of a sexual nature, but they actually use similar terminology of a forged digital likeness. So this is language that exists at the federal level as well.
Thank you, Mr. Chair. I was really totally sold on this bill until the word redistribution arose, and that causes me a little concern. So we just learned yesterday, we had a bill in this committee yesterday, and somebody created a funny video and sent the video out, and apparently it's gone viral, I'm told, and it's been subjected over 1 million viewings. Now, that video doesn't implicate this bill, but it just shows how stuff that appeals to people, that looks funny, can innocently be redistributed all over the place. So I'm looking at the language in page 2 near the bottom. It says a person may not knowingly distribute a forged digital likeness if the person, 1, distributes the forged digital likeness as genuine, and 2, knows or reasonably should know that the forged digital likeness is not a genuine visual representation or audio recording. So let me posit an example. Somebody creates a forged video likeness or audio recording and sets it out there into the internet sphere, and people start to look at it and they find it entertaining, funny, etc. And then a newspaper article is printed and gets some circulation that it's not real. Nonetheless, it is funny, it's entertaining. Would this bill criminalize people who saw it and knowing it was not real, still thought it was funny, and then shared it with others or redistributed it? That's my question.
So you have to knowingly distribute it, the digital likeness, and you know that it's forged, and they reasonably know that it's not a genuine visual representation or audio. So let's take
that's all part of my hypothetical.
So let's take the Pikesville situation. You know, all those people were sharing that. They didn't know, and they couldn't have known. Now they should. But what if they said, you know, I never read the newspaper. I had no idea that this was fake. Well, I would still have to prove beyond a reasonable doubt your knowledge. And if you didn't have the knowledge and just said I didn't realize that it was fake, then I couldn't prosecute you under this law.
Well, let's assume hypothetically they did know it was fake. It was clearly, they had heard somewhere that it was a fake. They knew it was a fake. They still thought it was funny and entertaining. They thought their friends would enjoy looking at this entertaining image, and so they share it with their friends.
Well, I think under the last sentence about the free speech and the First Amendment is if they put it out there and added, you know, laugh out loud, LOL, and things like that, that would probably prevent me from prosecuting.
I'm looking at the last sentence on page 2. It says distributes the forged digital likeness as genuine. And my question is, if I simply push the button on my cell phone to share an image, does that constitute distributing the image as genuine?
But it's
in and of itself.
And knows or reasonably should know the forged digital likeness is not genuine. So it says and. You need the and. You need both.
Yeah, I'm positing that they know it's not, but they find it funny anyway, and they push the button on their cell phone to share it. Is the mere act of sharing it, does that constitute distributing it as genuine, which is one of the requirements in order to be held criminally responsible? See what I'm saying?
Yeah, I do. I think it would be close, but certainly I think we have to rely on prosecutors to be looking at, you know, at the real cases.
I'm seeing the university law professor. He looks like he's interested.
Yeah, please. Professors are good.
Okay, so there's a couple of words in this that are doing a lot of work for us. So the first is a presentation as if genuine. So as you pointed out, an LOL or the context would matter. Let me give you some real life examples because sometimes I think that helps us work through it. If the video is funny because it shows you doing something you clearly didn't do, couldn't do, wouldn't do, shouldn't do, that's why it's funny, it's clearly not genuine by context. And so that would be your argument as a defense. I presented this as satire. That is why, almost by definition, it doesn't criminalize parody. Parody is funny because you know the impersonator on Saturday Night Live is not the actual president, chief of staff, whoever they're impersonating. So most of what you would find in the land of online memes are clearly silly. They're not presented as if genuine. The other thing that does a lot of work here, as you did point out, is we have to know that it is fake, and then we have to present it as if genuine. So there is a difference between your pressing the button and blanket sharing it, and your pressing the button and blanket sharing it with a, can you believe what this person did? Or look at what I did. I just got back from doing this amazing thing in the video. when I didn't do that thing in the video. So I believe that the edge cases that we found most interesting, in full disclosure, to present to our class is imagine a social media feed that is dedicated to creating parody videos. The individual videos are not labeled as parody, but the context of the overall feed is. We believe it makes sense to consider that context so that we don't criminalize the person creating the initial parody, but we do criminalize anybody who's resharing those videos as authentic with their audience suggesting they are real. It's the presentation as if genuine.
Okay, so you're saying just pushing the button doesn't do it. You'd have to do you'd have to add some gloss to it. Say, you're not going to believe this. He actually said this, and then share the video as if you're suggesting that the video is in fact accurate.
If you know what is...
And when you know it's inaccurate.
Right, if there's no editorializing. I believe you could still be criminalized under this if you know or reasonably should know that what is in that video is fake and you do nothing to disclose that you know or believe it is fake.
So you think just pushing the button itself would be criminal activity on someone who pushes the button?
So I think the justification for that is that our goal is to stop the propagation of these types of fakes on the internet and their presentation as if genuine. And so I believe that if you are resharing something, there's a strong argument that that's exactly the type of behavior we're seeking to criminalize, acknowledging prosecutorial discretion.
Gotcha. Thank you very much.
Thank you very much. When you were talking about genuine, you used the word authentic. Is there a distinction there? And as I'm looking at the word genuine, I mean, I know what I believe genuine means, but is this something that should be defined?
So the word genuine, I appreciate the question, thank you. There's probably other terminology or terms that could be used to structure a similar bill. And obviously we would be in support of anything that gets to the goal of targeting and criminalizing the evil we want to criminalize. Genuine does a lot of work when you combine it with things that are indistinguishable. So this isn't presenting a cartoon as if genuine. This isn't presenting a work of art as if genuine. This is presenting an indistinguishable digital likeness created with computer tools that is genuine. I'm not sure if that helps address the question.
No. Let me ask this. In the past, we've had issues in this state with the distribution of child pornography. So we've had child pornography laws, but in the context of sexting, where we now have had juveniles who have been prosecuted for distributing child pornography of themselves because they were underage themselves. So the question that I have is, could I, if I created a forged digital likeness of myself, could I be prosecuted under this law?
Take this one. Yes, I do think in those circumstances you could be prosecuted. You could be prosecuted if it meets all the other conditions. So if it is being presented as if genuine and if it is an authentic representation. I do think that could be criminalized because that's still putting this sort of falsehood, this false image in the ether to be distributed. And at least at the way the bill is drafted now, it doesn't require any legally recognizable harm. The harm is to society being unable to trust testimonial evidence. So in certain contexts, yes, that could be criminalized.
So I'm running in a district that is full of people who believe that their representatives should be extremely healthy and buff. So I create this image, put my face on this Arnold Schwarzenegger-like person, put it out there because I want to be buff, and you have to believe in buff people and vote for the buff man.
I'm not going to run against you.
There are some very interesting edge cases, but the fact that somebody might be prosecuted for driving 66 in a 65-mile-an-hour zone, I don't think argues against the existence of speed limits, if that makes sense.
But I could be prosecuted.
Yeah, Yes, because I think, the countervailing argument is we don't want somebody to be creating images of you the opposite, right? We don't want them to be taking away your control over your likeness against your will that way. And we've seen some examples where people are using this technology to change what's printed on a sign, to change what's printed on a T-shirt, to make it look as if, yeah, you ran the marathon, but you ran it wearing a T-shirt that represents something you don't represent. So yes, I think we have to. I think this is the sort of, what is the national harm to forging one $20 bill? Maybe very little. What's the harm to everybody printing 20s in their basement? Undermines the currency. What's the harm to creating one edge case small deceptive deepfake? You could argue it's narrow. But if everybody floods the zone with fake images and they are all indistinguishable from the truth, they don't prompt any follow-up questions. And how do you say it's fake? This image is fake. Look at the real image. Well, isn't the real image fake? And we have a problem where we've undermined the marketplace of ideas. We've effectively undermined that which the First Amendment seeks to protect.
Thank you.
Did you ask the question, did you doctor the photo yourself?
Yes.
Did you trust it?
Yes, and he said yes. Yes.
Yes. But, and let's remember, it's narrow circumstances. So if, by context, you say, this is what I want to look like in 2026, or wouldn't it be great if I looked this way, or we're talking a small watermark in the corner that says AI generated or generated with AI tools, that alone is enough because you're no longer presenting it as a genuine selfie.
Half the people on the dating apps are going to get in trouble. Right? All right, good. Go ahead, Senator. Go. You're good.
That just, when you say that, just begged another question. So can I shield myself from being prosecuted just simply by putting AI generated, but I've, again, created some sort of, a forged digital likeness?
Yes, and the reason why is that it prompts the viewer to know that that's not real. So that gives your forged digital likeness marked with AI the same weight that Monopoly money would have when I go to spend it at the store.
Why didn't you all include that? I don't think it's included, is it?
It's included both as an affirmative defense, and you would not be presenting it as if genuine if you presented it as if AI generated.
So that's what you, okay, so that's what you mean in E. Okay. Thank you.
Thank you.
Thank you. If I can continue with the professor, thank you. I'm kind of on the fence with this bill, but let me just ask two questions. One, if I were to share something and somebody at an event and it was not, and I did that, and I'm just kidding, and I say, yes, I was there, and the event really didn't take place, would that mean that I am guilty under this bill?
We rely, in cases like that, on the reasonableness of somebody knowing or having known it was fake. So this is the situation is captured. I give you another example that's clear that. If you portray yourself standing next to a historical figure that is generally known to the public, that person is deceased.
Right.
Clearly, that is not being presented as if genuine. If you're presenting yourself showing up to an event that never occurred, it depends on the context of presenting it if genuine, but that wouldn't be presented as if genuine if it was an event that clearly didn't occur. If instead it portrays yourself building homes in a disaster zone that you never visited, and you're putting it out there as if real, that would be problematic. So we're relying on the reasonableness of the public to make these determinations, which is rooted in our common law foundation of forgery. Right? There's a difference between forgery and satire and parody and later production.
In that case, are we relying on the perception of the public or the prosecutor?
Can you clarify?
Yeah. Somehow, if I'm guilty, the prosecutor's got to make the ultimate decision, right? If the prosecutor has to make the ultimate decision, and I say it was a joke, and they say it wasn't a joke, or I say, I was only kidding, I can't really prove that. but the prosecutor can still hold me accountable. Is that right?
I believe courts are well positioned to make that, and juries are well positioned to make that determination.
That's my friend right there. That's my
Defer to the
buddy.
expert on that.
Yeah, right.
I mean, I understand getting in all these hypotheticals, but
Right.
please remember, you know, we're talking about something that really happened
Right.
that we didn't have an answer for. And to answer your question is every time we make decisions about prosecuting, we think about what if 12 citizens from Baltimore County were trying to decide if this person were guilty beyond a reasonable doubt. I always think of that. And,
And
you
the
know,
standard is beyond a reasonable.
oh, yeah, this is criminal. So it would have to be beyond a reasonable doubt. And so every time a prosecutor evaluates any case, they would say, all right, well, I can prove it. I can get over motions, you know, motion for judgment of acquittal. Well, that's not usually how I raise the standard. I'm like, can I win this case in front of a jury of 12 people? And the other thing is, please remember, we got enough to do.
Right.
I just want this guy.
Right.
Okay? I mean, the prosecutors in the state of Maryland are very, very, very busy people, and I haven't seen anybody who's trying to find out how they can catch you, and certainly not me.
That would have been in trouble, but okay, thank you. Thank you.
Senator James, do you have another question?
No, I'm okay.
No further questions. Thank you all very much. King, can you split it up?
It's me too. Scotch number got it.
Fantastic. Awesome. All right. We have two people joining us virtually, one proponent and one opposition. So we're going to start off with the proponent. Is Shanesi DeBerry Melvin?
Hi, it's Shaughnessy DeBerry. I don't know how you got Melvin on there, guys. Can you hear me?
Yes. Welcome.
Awesome. So I do support.
Joining us virtually, one proponent and one opposition. If you could, if you're streaming it, if you could shut down the stream on your browser, and then come off of mute, that helps. All right. Mr. Barry, you're up.
Okay, it's Shaughnessy DeBerry. I'm not sure how Melvin appeared right there. Nonetheless, I am in support of 362. There are a couple of things that stood out to me: drawing, forgery, and distribution. As I attached with my request to speak virtual drawing that was distributed in a court filing with 3 different hand-drawn signatures, which would be digital signatures of a former government employee. And when we talk about digital likeness, from those 3, I cannot gauge, and any reasonable person who I shared it with wouldn't be able to gauge if it was the actual signature of the government employee or someone else. You guys bring up a lot of topic about the Attorney General's office. This was distributed to me through an assistant attorney general. And so I hope that you guys will look into it, because I know that you guys talk a lot about the memes and the viral videos and parodies and things like that. But there are people who actually are receiving documents in court. I believe that the judge from Prince George's County said someone was logging in using her digital signature. And you guys did not address that in digital likeness. But I do think that this bill would be the start for even myself to bring back in the coming years conversation and opening up a Pandora's box about the serious forgery, the serious distribution when we talk about public trust in the community as it relates to those who are in the government who may draw someone's name on a tablet and upload a PDF to a court, which would be distributed or e-filed of service to someone like me. And now it's a question of, these are 3 different signatures. They do not look the same unless this person has personality disorder in their handwriting. And it raises a question of their digital likeness and who would need to be prosecuted in a situation like that. So thank you guys for bringing this to the forefront. I look forward to advocating for it with my 20 years of digital and technology experience. Thank you.
All right. Thank you very much, Mr. Berry. That'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel with Mr. Zacher. You're up. Welcome.
Thank you. Good afternoon to the committee. My name is Jeremy Zacher. I'm an assistant public defender in Baltimore City. I work in the juvenile division. The Office of the Public Defender asked for an unfavorable report on Senate Bill. I forgot what the name of it was. Of this Senate bill, sorry. This bill sweeps very broadly. I want us to remember what the previous speakers said. This bill does not punish harm. It punishes behavior. And so we've already heard several examples where a forged digital likeness could be created that causes absolutely no harm to any citizen or any individual, yet is still criminalized. You can imagine the situation where someone takes a photo of themselves and then uses Photoshop or some other enhancement application to change the color of their hair, to shave off a few years off their face, to shave off a few pounds, and then redistributes it without any kind of labeling and saying, hey, look how good I look. You're now a criminal. Congratulations. The wording of the bill is very vague. The bill criminalizes misrepresenting the appearance, but doesn't really describe how much needs to be misrepresented or whether or not that misrepresentation puts the subject in a better light or a worse light. It talks about reasonableness, a reasonable person, and the genuineness of the image. Again, these are very subjective terms, and the previous speakers are suggesting we just put ourselves into the hands of the prosecutors because they know what to do. This bill is overly broad and can bring a lot of innocent behavior into our criminal justice system, subject to a 3-year penalty. Certainly there are laws that protect against things like creating new money, like counterfeits, forgeries, and as Mr. Schellenberger described, that person might be charged with inciting a riot. It depends, but this bill needs a lot of work because it will ensnare a lot of innocent behavior in its grasp. That's all. Thank you very much.
Excellent. Thank you very much, Mr. Zacher. Questions from the committee? All right, seeing none, thank you very much. All right, with that, that'll conclude the testimony for Senate Bill 362. Thank you very much, Senator Hester. We'll now move on to Senate Bill 311 with Senator Simon-Ayer. Welcome.
Thank you, Mr. Chairman. I miss my days on JPR. I started out my public service on this committee, and I believe Senator Muse was on there at that time. You pinged around a little, but you're back. But anyway, for the record, Senator Simon-Ayer presenting Senate Bill 311, and I'm thankful for the broad support that we have on this bill. If you'll recall from last year, we passed Senate Bill 480, which was Protecting Election Officials Act. It passed unanimously on the Senate. Matter of fact, several of you co-sponsored that bill. During that hearing, it actually came to our committee because it was in election law, and we were talking about it, and I asked them, I said, you're including family members in these protections for election workers. I said, we already have a current statute that protects election officials and others. Would you mind if we put our family members in there? And they said, well, that's a great bill for next year, but this is election law, that's over in criminal law, so we'll have you do that. So I put a bill in. So basically what this bill does is it adds family members to the protections against threats. Now these threats are an existing law. It's kidnapping, take the life, or physical harm. As elected officials, we know what it's like to run. We have to have thick skin. You know, we get plenty of insults, and people are emboldened behind their keyboards these days and say all kind of things. That's not what's covered with the protections. That just comes with the territory. But let me tell you what this bill does not do. It does not expand the offices protected, and it doesn't change the penalties that are currently there. In federal law, they're felonies. They're misdemeanors here, but it doesn't change that. All it does is provide protections for immediate family members who are being threatened simply because they are a family member of an elected official or other office. So why do we need this bill? The threats are increasing against officials and also family members. I asked the state police to provide some statistics. From 2014 to 2022, an 8-year period, there were less than 10 cases in that 8 years. Since 2023 to present, there have been 42 cases in just 2 years. Last year, we had 21 cases with 10% of them being against family members. Nationally, we're seeing that. You saw it during the last election. They had both Republican and Democrats being threatened. Their families were being threatened. And the minority leader in the House, Jeffries, said, and I quote, "It is imperative that Congress provide maximum protection for all our members and their families moving forward." So they're recognizing it is an issue. And sadly, more and more families are being drawn into the world of violence that they never should have to experience. We want to encourage public service, but the rising serious threat against them and their families will have a chilling effect without these protections. So with that, I would ask for your favorable consideration.
Mr. Chairman, members of the committee, good afternoon. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland and Executive Director of the Maryland State's Attorneys Association. And I am asking the committee for a favorable report as to Senate Bill 311. When you get threatened in the state of Maryland, you're an elected official, you get me as your prosecutor. So I'm very familiar with this. Besides coming here and testifying, I'm also the person who prosecutes cases for people who threaten judges. Sadly, as Senator Simon Ayer indicated, I want to thank him for sponsoring this bill. It's been increasing and increasing. It just goes to show you, I hate to say it, where there's smoke, there's fire. And it's just a matter of time before we get more and more cases where families are threatened. It's a very good bill at a very good time. And on behalf of the Maryland State's Attorneys Association and myself as the prosecutor who does these cases, we'd ask for a favorable report as to Senate Bill 311, and I'm happy to answer any questions. Thank you.
All right, excellent. Senator, thank you very much. Thank you. For
Okay, so there was no other verbal, I didn't.
No, I'm going to call them. I think we have, Sarah Sample from Mako is here. Steve Kroll just went, and Brandon Butler. And then we'll switch to the opposition panel, which is just one person virtually. Welcome.
Thank you to the chair. Thank you to the members of the committee for having me today. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we are here to support Senate Bill 311. I'm pretty much saying me too, but I really just wanted to confirm that we are seeing an increase in these types of threats. And without the provisions of this bill, we're worried that this is going to discourage public participation, public service, and that's really important to us. So we support this extension to immediate family members, but also just wanted to highlight that, you know, it's not just our elected officials and their families. This is also affecting health officers, election judges, as you've heard, public safety officials, teachers, school officials, and our DEI directors. So it's extensive. We really appreciate this bill. We support it. It's a bad situation out there, but we would definitely urge a favorable report on this bill. Thank you so much.
Good afternoon, Mr. Chairman, members of the committee. Brandon Butler, Pinnacle Strategies, on behalf of our client, the Center for Election Science, also in support of Senate Bill 311. The Center for Election Science focuses on innovations in elections through approval voting, but we're also in support of secure elections and through protecting elected officials. That's why we were supportive of Senate Bill 480 last year. Of course, as the senator said, this bill is the focus on what happens as a result of elections to election officials or to elected officials. So we recognize that when someone runs for election to public office, that it's often a family decision, and therefore we believe that immediate family members should receive the same protections under the bill. For that, we ask for a favorable consideration.
Excellent. Thank you very much. Questions from the committee? All right, seeing none, we'll now move on to the opposition panel. Ms. DeBerry, you're back. Welcome.
Hi, can you guys hear me?
We can.
Okay, thank you so much. So I oppose this, reason being, as always, if I come to you guys, it's off personal experience. I had a judge that refused to recuse herself from my case. I exercised my First Amendment in saying, like, her children's name, your Dusty A mom is violating my rights, blah, blah, blah. The appellate court for the state of Maryland said, although no threats existed, they were putting a protective or a gatekeeper order, well, I guess a restraining order for me even mentioning the family members that were listed on her website, not in a threatening way, but I mean, if you're going to play with my children, then we are an open playground in First Amendment. This judge specifically told me that the prosecutors had the right to say I belonged in a cage. And so I think that you guys need to be very delicate when you are trying to protect people, because you may end up violating other people's. I know exactly why I'm being targeted by the state of Maryland. Maryland is the home of Brady prosecutors, but I don't know people that wake up every day and say, I want to kill an ASA or whatever the case may be, a judge or anybody. Look at the root of these things and perhaps consider that we do need to, nobody should make a threat or assault anyone. However, you guys do need to seriously consider what is happening to those of us who are being silenced. And the appellate court, they're already doing things and putting things in place to put, okay, you can't say anything in a court file about this person. Never has anything. What would I gain from bothering a judge? Luckily, she recused herself off my case. But look at the tax dollars that you go into trying to protect people who do things and throw rocks and hide their hands and then are able to twist the narrative. And we come here and there are seriously judges like, unfortunately, the one who was murdered untimely by someone. And we're not looking at the root of the issues. Why is a person feeling like they need to harm a judge or their family? What is the judges and the prosecutors doing to people to make them feel that way? It's a disgusting and delicate matter as always, but it needs to have a little bit more thought put into it before everybody out here look like me, which looks like I want to harm judges when I don't. I want to be left alone.
Okay, thank you for that. Questions from the committee? All right, thank you, Ms. DeBerry. With that, that'll conclude the testimony in the hearing for Senate Bill 311. Thank you very much, Senator Simon-Ayer. We'll now move on to two bills from Senator Jackson. We'll start off with Senate Bill 271. Senator Jackson, welcome.
Thank you, Mr. Chairman, members of the Judicial Proceedings Committee. For the record, Senator Michael Jackson, District 27. Senate Bill 271 is a very direct piece of legislation that came to me from the Maryland Sheriff's Association. And Mr. Chairman, is your, if I could bring up a panel.
Yes, please. Ms. Manfield, is Sarah Sample, come on up.
Thank you. The bill simply provides clear protections to the civilian employees of sheriff's offices under the Maryland Tort Claims Act, bringing them in line with the statutory language that's already in place for state's attorney's offices, liquor boards, and some others. Issues don't arise often for civilian employees, but we have an obligation to protect them as well as we do for those in uniform. The ambiguity within the law is what we're trying to correct here today. I believe that the panel will discuss a particular incident or two that prompted the need for the legislation, but the most direct incidents will likely involve PIA requests and the like. These protections are already in place for both sheriffs as well as deputy sheriffs, and we're just trying to expand that to the civilian employees who are under the direction of the sheriff in the agency. As you all likely know, my prior career would lend to my understanding of this, where we have the challenges of who would represent those employees who are working under the auspices of the office, which means they're working on the auspices of our government. I believe this legislation will provide the needed protection and remove all fears from our public servant employees as they provide the services that are needed for our respective counties as well as the city of Baltimore. With that, Mr. Chairman, Mr. Vice Chairman, members of the committee, we ask for a favorable report, and I will also, at your leisure, turn it over to my panel, but I'll stay here for a question. Thanks.
Great. Thank you, Mr. Vice Chair, members of the committee. Andrea Mansfield with Manus Canning and Associates here today representing the Maryland Sheriff's Association. And really want to thank Senator Jackson for sponsoring this piece of legislation. He actually gave a very thorough overview of what the bill does. This issue was actually raised by the Assistant Attorney General who works in the Treasurer's Office that works directly with the Sheriff's offices. And really in the need to clarify this just to ensure there was not ambiguity in the statute, because there have been a couple situations where this has arisen. The civilian employees in the sheriff's office, they were represented by the Attorney General's office, but there was a process that they needed to go through in order to get the approval to do that. This would clarify that, but I think most importantly what this would do in that section of the statute that defines state personnel, if you look at the state's attorney's offices, the employees of that office are covered under the Maryland Tort Claims Act. Liquor board employees are covered under the Tort Claims Act, as well as election offices and so forth. So this is really putting the employees of the sheriff's office on the same level footing as the employees of all the other constitutional statutory offices that are outlined in that section of the law. So with that, we would urge a favorable report of the legislation. Thank you.
Thank you to the chairs and members of the committee for having me today. My name is Sarah Sample. I'm here from the Maryland Association of Counties, and we are here to support Senate Bill 271. I think ambiguity is a really great way to describe this sort of segment of government liabilities, particularly when it comes to sheriff's departments. You've heard last year in the bill that we've had that we have shared functions. We have sheriffs and deputies that are doing things in a state capacity and a local capacity, and liability for those actions are covered accordingly. And we brought a bill to this committee last year with the support of Senator West and also Delegate Embry that helped clarify some of that responsibility, and it helped calm some of that back and forth that was happening between the local attorneys and the assistant attorney generals. So we appreciated that this committee understood that last year, and we think that this bill is doing the same thing. It's really just clarifying that responsibility and representation for the civilian employees of the Sheriff's Division. So for those reasons, we would certainly urge a favorable report on Senate Bill 271. Thank you so much.
Good afternoon. Thank you to the chair and the members of the committee. My name is Kirsten Lastilla. I'm an assistant attorney general, and I represent the Maryland Sheriffs. In conjunction with the state treasurer's office, the Office of Attorney General has submitted a brief written statement, which I believe you all should have. Our position is that this is urging a favorable with amendments. The amendment is a slight, just sort of purpose statement to indicate and clarify that this bill is not intended to change anything related to the bill that Ms. Sample alluded to that passed last year. As was previously noted by another member of the panel, this bill is basically to make the definition of sheriffs consistent with the definition of state's attorneys, judges, circuit court employees, and that along those lines. And so for that reason, we urge a favorable with amendments posture. Thank you.
Questions from the committee? All right, seeing none, thank you very much, Senator. We'll now switch to the opposition panel. We're joined again by Mr. Berry virtually. Mr. Berry, you're up. I'm sorry, Mr. Berry, I think you're on mute. If you can unmute yourself. Yeah, there you go.
Can you hear me? Okay.
Yes, we can.
Okay. Yesterday, Attorney General Brown issued guidance for law enforcement in regards to the risk of civil liability officers if they don't, I guess, illegally do the immigration detainers. And he was heavy on his digital printing civil liability of officers, and sheriffs fall under officers. So for this bill to insinuate that sheriffs are not covered, it's contradicting to a layperson, which I am. And then with that being said, trying to incorporate employees of the sheriff office for community, I'm sorry, for immunity, I'm kind of baffled that immunity would ever be needed. And it seems like something where you guys are trying to put a Band-Aid over something that needs brain surgery. Nobody needs immunity if they're doing their job correctly. Nobody needs immunity if they have public trust and or community trust, and if they're not violating rights. Right now, a judge, the same judge I just recently testified about, has sheriffs looking for me. So if those sheriffs violate my rights because that judge was in her feelings, I want to sue them. I think I have, a year or two to sue them because they should not touch me because I've already asked to be left alone. I've already filed in the case, and this court lost their jurisdiction. issuing this bill would allow for people like myself to not be able to go for any type of redress or remedy or relief for the harm that's been caused to us. But it seems like, based off of what Attorney Brown said yesterday, immigrants get more protections than we do, and that's very interesting. So please look into that, and I oppose this bill.
All right, thank you very much. Questions for Mr. Berry? Seeing none, that'll end the hearing for Senate Bill 271. Now move on to Senator Jackson with Senate Bill 351.
Thank you, Mr. Chairman, members of the Judicial Proceedings Committee. May I bring up my panel?
Yes, I have Brian Gill, David Lewis, and Brian Blumbaugh.
Thank you. Gentlemen. All right. For the record, Senator Michael Jackson from District 27 on behalf of Senate Bill 351. Senate Bill 351 came to me from the State Law Enforcement Officers Labor Alliance. The bill's pretty straightforward and simply alters the mandate for state troopers to live within the state of Maryland, and it changes the mandate to allow them to live within 25 miles across the state border. As someone who previously directed an agency, I know firsthand the challenges of recruiting and, most importantly, retaining officers to remain in service to our citizens in our jurisdictions. I view this legislation as simply a tool for the agency to that end in order for us to be able to recruit some additional officers and to maintain them. To that end, these officers are willing to forego certain benefits that they currently have, knowing that once they leave the state of Maryland, they would have to leave their vehicle at a barrack closest to the state line, as well as their weapons, and they'll speak to that further. With our borders being so close to the District of Columbia, Virginia, Pennsylvania, West Virginia, and Delaware, this change would allow our officers some flexibility and the agency some flexibility to recruit and retain. I believe this is a simple change. I support it wholeheartedly. Again, from my experience, we had a similar piece of legislation for our deputies, and it helped us tremendously. So with that, Mr. Chairman, members of the committee, we ask for a favorable report, and I will turn it over to my witnesses, and I will stand for questions. You want me to sit down or for them to? Okay, thanks. Yes, sir.
Good afternoon, committee. I'm First Sergeant Brian Gill with the Maryland State Police. I'm also the president of the State Law Enforcement Officers Labor Alliance, known as Loyola. First, wanted to thank Senator Jackson for his continuous support in introducing this bill for us. We believe that the 25-mile radius, living within it, is well within our ability to recall our officers. We believe that this currently is an antiquated statute that allows for us to have to stay when it was introduced when troopers were required to stay at barracks, which is no longer the effect. Also, out of our 9 departments that we represent, Maryland State Police is the only one that is required to have an in-state statute. And just request a favorable report on this. Thank you.
Mr. Chairman, if I might, I did forget one note. Each member should have in your packet an amendment. The original drafting of the bill also included civilians. That's not needed. Civilians did not have a residency restriction, so if you don't have it, it should be on your computer, but you should have that amendment. Just wanted to make sure that goes on the record. So this is for the troopers only. Thank you.
All right, good afternoon, Mr. Chairman, members of the committee. My name is Dave Lewis. I'm a first sergeant with the Maryland State Police, and I'm currently the vice president of Loyola. So I'm here to ask for a favorable report on Senate Bill 351. As you heard, the bill makes changes to residency requirements. As President Gill said, we represent 9 agencies at Loyola, and the other 8 can all live out of state. So we're not trying to come up with something new. All the other 8 agencies have policies on how to handle this, so it's already been established. To address some of the concerns of the agency, I know their fear is that we will not be able to be recalled to duty right away. That's why we asked for just a 25-mile limit. Right now, I have 25 years on, and I've never been called at home to report to work immediately. It doesn't happen often, so it's really not a concern. Currently, we have troopers that drive 2 hours each way to work. So if we have the ability to have troopers working 2 hours from home against their will, 25 miles out of state is not going to be something that's going to be a hindrance to the agency. We believe also it'll help with recruiting. Like myself, I started when I was young, I was single. I could move to the state. I could go anywhere. It wasn't a big deal. Now I'm currently a father of 3, married. If I had to move somewhere and move my children to a different school, I might not consider coming with the Maryland State Police. Right now, we're all fighting for the same pool of qualified applicants. So the ball's in the court of the young guy trying to pick which agency to go to. So we need to try to make it better to get people from out of state. With that, I just want to thank everyone for this opportunity, your continued support of Osceola. I thank Senator Jackson and ask for your favorable report. Thank you.
Good afternoon. My name is Brian Blueball, and I'm a sergeant with the State Police and president of the Maryland Troopers Association. In regards to this bill, just an example of myself, growing up in Pennsylvania, I lived about 100 yards from the Maryland state line. My intentions were to go to college and become a Pennsylvania trooper. I learned about the cadet program for the Maryland State Police, and I could get hired at the age of 18. And I could still live out of state to do that. And that's what I did. But then whenever I went to the police academy to become a trooper, I was then required to move to the state. So I moved. Next to where I grew up, my grandparents had a home. Once I moved and became a trooper, when my grandparents passed away, I would have loved to just purchase their house or take possession of that house and live there, again, only a few hundred yards away from the state line. However, I could not do that because of this current residency requirement. Currently now I live near the Hagerstown, Maryland area, and I'm only 1 mile from the Pennsylvania line as it is. And there's only 11 miles of Maryland between the borders of Pennsylvania and West Virginia where I'm at. I talk to troopers from West Virginia and Pennsylvania on a regular basis and residents from those areas. I encourage them to come be a Maryland trooper. And there are several times they have said, I would, but I'm not moving myself or my family from my current place to, just to become a trooper in Maryland. With the recruiting the way it is, this is definitely something that could be easily fixed and bring, those extra applicants that we desperately need to fill all the vacancies we have. Therefore, I ask for a favorable report.
Thank you, Mr. Chairman, and thank you, Senator, for bringing the bill. I think back to my days on the Annapolis City Council and working very hard with our police department, of course, at a council level, to try to recruit and retain law enforcement officers, and them talking about needing the flexibility built in to be able to get officers from other areas. But they also talked about not having necessarily the culture where if kids don't grow up next door to police officers, if they don't see them coaching the local baseball game, if the officers aren't a part of the community, then sometimes you don't develop the culture where your dream is to grow up and to serve and to be an officer. If we have our officers residing more and more out of the state, out of the jurisdiction that they serve, how do we then overcome that culture where kids aren't being raised in the presence of officers so that they aspire to those professions?
That's a terrific question. And as we grow in the business of public service across the board, but particularly to address your question, I'll speak from personal experience as well as what we're trying to do here. So when I got elected sheriff for Prince George's County, we took a good look. I grew up in that agency, and we watched over the years folks who had decided that when they retire, about halfway through their career, they begin to say, I think I want to move to a more rural area, or I may want to purchase some land in another county. And so we saw folks, deputies at the time, to begin to purchase properties in the outlying counties for us, it was Anne Arundel, Calvert, Charles, St. Mary's counties, and they would make that trek, but they did that because of the things that were important to them. Smaller classroom sizes, more bang for your buck. When you buy a house, you can get some property versus where you could possibly, where they were living in Prince George's County. But what we made was a commitment within the agency to ensure that we stayed in touch with our community. Because even though they moved, they still were rooted in the county. Their service is rooted in the county. Now, that goes back to a leadership component that I think is vital in any agency, and that leadership has to be committed to getting out of those cars, touching the folks, and having that conversation, as the trooper spoke about his colleagues in West Virginia and the others. That's a concerted effort. But I can tell you, in the region that we are in, it is a very tough battle, as you know, being on the city council, and you had Anne Arundel County Police and state police and others that were trying to, grab your folks. I think that's a commitment of, we don't need, and I'll say this for the record, we don't need community policing federal dollars to ensure that folks understand what they are rooted in the community. And so again, that's a community piece. I don't think this will impact us negatively. Let me say that.
Okay. Thank you for your response. Thank you, Mr. Chairman.
Excellent. Further questions from the committee? All right, seeing none, thank you very much, Senator. Thank you all very much. Thank you. Thank you for your time. All right.
Yes, sir.
With that, that'll conclude the hearing for Senate Bill 351. We'll now move on to Senator McCray with Senate Bill 370. Senator McCray, did you want to bring up your sponsor panel?
Yep, I believe I'm supposed to have a panel with the Assistant Commissioner and Dr. Oboy.
Yes, come on up.
All right, you had me looking. Is the Assistant Commissioner here?
That's me.
Okay. Oh, so you both these?
Yes.
All right, perfect. All right, well, get started, Mr. Chair. Yep. Mr. Chair, Mr. Vice Chair, members of the committee, Corey McCray representing Legislative District 45 in reference to Senate Bill 370. Senate Bill 370 is one that I'm doing on behalf of my administration. I think that when I say I feel very comfortable in saying that my mayor has been a very much vocal leader from a national standpoint of thinking of things from a public health standpoint versus a criminalization standpoint. And this is something that we've already done in past years, Mr. Chair. I just want to remind folks in 2021, we passed this bill very similar, like when we're thinking about decriminalizing what we call paraphernalia from that standpoint. I'm very supportive of it, and I just wanted to say we do have a subject matter expert that will lean in reference to why we should be thinking about those that enter into the penal system and thinking about the public health standpoint, the long-term ramifications when we don't from that piece. So I'll defer to Dr. Oboy and with our health department, correct? With Baltimore City's health department on why this is important. Thank you.
Good afternoon, Chair Smith and members of the committee. My name is Dr. Christine Oboy, and I serve as the Assistant Commissioner for the Bureau of Ryan White and Community Risk Reduction Services at the Baltimore City Health Department. I am here on behalf of the Baltimore City Administration to support this bill. Senate Bill 370 will lead to more people accessing life-saving syringe services programs, or SSPs. SSPs provide clients with clean syringes and connect them to health and social services, including addiction treatment. They also provide naloxone and overdose prevention education. Clean syringes prevent the transmission of infections like HIV and hepatitis. SSPs have been legal in Baltimore City since 1994 and statewide since 2016. According to the CDC, SSP participants are 5 times more likely to enter drug treatment and 3.5 times more likely to stop using injection drugs. Even though SSPs are legal, we often hear from our clients that they are afraid to engage with our services because they fear getting arrested. This bill's passing will quell that fear. Many studies have shown that SSPs reduce syringe litter. In the past 10 years, our SSP clients have returned over 10 million syringes. Studies also show that SSPs do not lead to increased drug use, overdose, criminal activity, or accidental needle sticks among law enforcement. Please note that this bill is about paraphernalia for personal use, not for manufacturing or selling drugs. Paraphernalia criminalization exacerbates addiction and makes recovery more difficult by discouraging people from accessing life-saving services and saddling them with legal fees and challenges getting employment or housing. The current law has not worked, but removing this barrier to participation in SSPs will only strengthen our state's response to the opioid crisis. I urge you to vote favorably on Senate Bill 370. Thank you.
All right, seeing none, thank you very much, Senator.
This is the best JPR hearing I've ever had.
We've been riding hot for the last couple days, so you caught us on a cold swell. All right, we've got a couple of folks left to testify in favor of this bill. Darcy Kerwin-Garber, Jesse Dunleavy, and then Ronald Phillips.
Hi, Chair, committee members, thank you for your time. My name is Darcy Kerwin-Garber. I urge a favorable report for Senate Bill 370. I've been in public health and social services for over a decade. It includes state and local health departments, community clinics, homeless shelters, and I currently work at a syringe service program in Baltimore. So what we're talking about includes syringes today and paraphernalia. This is one of my personal syringes for my diabetes, but it is also the exact same type of syringe, both brand and make, that we have at our syringe service program for participants. This sterile syringe is a life-saving tool for anyone who uses syringes for whatever reason, and it doesn't make sense for any Marylander to be prosecuted for holding it. So I have the privilege of engaging with hundreds of your constituents every single week on outreach, where your constituents are coming, they are showing up for themselves, for their family members, making sure that they have sterile supplies like this, so reduce the spread of HIV, hepatitis C, to reduce wounds, to reduce overdose and death. Because really, there's nothing inherent to injecting or even smoking drugs to the spread of HIV and hepatitis C. It is only through the sharing of paraphernalia like this that has that risk. And currently, our law incentivizes people who share, incentivizes sharing syringes as well as littering syringes, where it makes sense if carrying this is legally dangerous, that then you might want to share instead of holding onto your own all the time. It also makes sense that if it is legally dangerous, that then you would try to get rid of this as quickly as possible rather than holding onto it to dispose of it safely, even if you're in a public space. So currently, Maryland forces our constituents, our family members, our loved ones to choose between what is healthy and safest for themselves versus what is legal. And so even if I happen to have a measuring spoon like this, I'm now at risk of 4 years of incarceration or a $25,000 fine. Doesn't make sense for something that is a life-saving tool. Now, we have participant cards that can protect against these legal measures, but these can be easily destroyed, these can be let go, they can be ignored. So what we're asking support of Senate Bill 370 for the dignity of people who use drugs, for our loved ones, for your loved ones, and for common sense measures that incentivize safety and health rather than fear. Thank you very much.
Hi, thank you, Chairman Smith and members of the Judicial Proceedings Committee for letting me speak on Senate Bill 370. My name's Jesse Dunleavy. I'm a lifelong Marylander. I have a master's degree in library science, library and information science, and after 40 years as an academic librarian and an educator, I've spent the last decade studying drug policy. And I've done a lot of research. I work with a lot of committees, both locally in the state and nationally. Our understanding has evolved a lot, so there is good news in terms of our moving forward with what we need to do. My goal is saving lives, preventing overdose deaths. Since 2017, when I lost my son to a fatal overdose, thankfully since then, we've learned that we really can't conflate addiction with moral deficiency. We've learned that those who struggle with addiction are often our most vulnerable citizens, and they didn't forfeit their right to health care. And in essence, there's just growing understanding, you hear it all the time, that we need to focus on support in lieu of punishment. And that's what paves the way to wellness and to recovery. Preliminary numbers, the CDC, I'm sure everybody sees it, the headlines are pretty prevalent, tell us that the overdose rates have gone down. And nobody would say that's not good news. I think they've gone down, and these are preliminary numbers, but they've gone down about 10% nationally and about 6% in Maryland. Again, it's good news. But the headlines can fool you because we still have nationally over 100,000 deaths per year. And when we declared the overdose crisis in 10 years ago, it was 50,000 deaths. So we're still over that 100,000 mark. We're still in the crisis zone. And also, we have to realize that the decrease has not impacted every segment of the population, that our Black citizens are dying at a faster rate than our white ones, and that is in part because of criminalization. And so I just urge that we do everything that we do to keep people alive and to stop criminalizing people when that doesn't serve them. Thank you.
Good afternoon, Chair, Vice Chair, Senate members. My name is Ronald Phillips. I was the project manager at Communities United and also a member of the Bridges Coalition. You heard some good points today. I'm just here as a mere witness of the practice that people that use drugs use, and it's very unhealthy. It is the sharing of syringes. People fear the fact that they can be prosecuted for having a syringe. Therefore, they use syringes that already are contaminated, blood-filled syringes that is resold to people in the street that need to get well, self-medicate. This is a health crisis. This is an issue that I've witnessed numerous occasions. People that I've worked with that I knew that was, sick and had hepatitis and HIV, but still sell their syringes for consumption, and it adds to this public health crisis. So I urge you to vote favorably for Senate Bill 370. Thank you.
Questions from the committee? All right, seeing none, thank you all very much for your testimony. We also have is Charlotte Hoffman, Samantha Kerr, and Merritt Williams. I'm sorry, that's unfavorable, sorry. Welcome.
For the opposition?
This is just, we'll wait for the opposition, but just to round out the proponents of the bill. So if Ms. Hoffman and Ms. Kerr, come on up.
Ah, Shiza. I didn't expect to be the first.
No worries.
And the first and only.
Welcome.
Thank you. My name is Candy or Samantha. I'm an alcoholic and I'm a member of the Bridges Committee and a person that works at a syringe service program in Baltimore City. You did hear a lot of good things already. And so really what I want to add to this conversation is that the syringe service program that I work for, we have had at least one participant that has been arrested. They've been pulled over. The police officer has seen a syringe in their vehicle or syringes in their vehicle, and they were arrested that day for the syringes. So that is a problem, obviously. It inconveniences them, it inconveniences, well, we spent the most of our day trying to triage that situation. And so this law of decriminalizing paraphernalia would give us back time, give us back energy, not just us, but also the people that are being arrested for that. Also, as a syringe service worker, I have to carry these. I have to carry syringes. I do that on my person because I'm a member of the syringe service program, but also even as a sober person, I still encounter people who use drugs. And I carry those with me. I do not want to be caught up in the legal system or arrested in any capacity because I am carrying syringes for other people. That is me as a syringe service worker. That is me as a human being. I don't want that, obviously. Another point or another thing that I want to add is I'm a member of the Syringe Service Program Advisory Board, and we have spent hours talking about what can we do to make sure that police officers and other people are aware of the fact that our members are members. And so we've spent hours talking about lamination and giving people lanyards with their cards and other things. And the reality of the situation is if we can have a favorable vote from y'all and everyone, and we can pass this, and we don't have to worry about spending money on paper and other things. Go ahead.
Thank you, Mr. Chair. So I listened to everybody, all the proponents come up, and unfortunately you're the last one, so I'll just
it's unfortunate for both of us, it appears.
Pardon?
I said it seems like it's going to be unfortunate for both of us. Now I got to answer all the questions.
It don't matter to me. So my son's a T1D, type 1 diabetic. My son has syringes because he has to have it just in case his pod fails. I think one of the biggest disservices we ever did to the addiction community was these mobile buses that gives out drug paraphernalia. They give out the spoons, they give out the syringes. Well, I think that's a terrible disservice. That just enables a certain mindset. So having said that, just carrying a syringe without any of the other pieces to it is not an illegal act. You can buy them in the store. It's the other elements that are necessary to create the paraphernalia piece. I just want to be clear on that. Like that's not, there's a lot of misinformation that gets put out there about that. So I just want to be clear on that.
I love that. Thank you. Is that do I get to answer? It's
sure.
A comment?
Sure.
Okay. So syringes also measuring spoon. Yeah, the measuring spoon as well. So I'm going to say lots of things in this moment. First, is your son white?
I don't understand how that plays into this, but I think it's pretty obvious.
Let's
Am I not allowed to?
No,
okay, never mind. I won't do it like that.
Into someone's personal life and so let's just maybe reframe what you're take a different course to your destination.
Okay, as a black person as a black person that's targeted by the racist war on drugs or the war on drugs, we don't have to use the word racist. I am targeted by the war on drugs because I am a black person. Specifically, if I live in different areas of the city, I'm even more targeted because it is more highly policed, et cetera, et cetera. So me carrying a syringe, just a syringe or a bag of syringes, if I am stopped, it goes a little bit further, it goes a little bit deeper than it might go for some people. If I have a syringe and a spoon, then we're gonna be in that situation again. I might have the syringe because I have diabetes, I might have the spoon because I have soup with me, right? It's, again, it's not just, or it isn't just having the combination of all of those things, right? There are a lot of factors which factor into people being stopped, yes, but also arrested. And so that includes, it can just be syringes, but it can also be syringe and spoon, it can be all these other things. Yes, is there another one?
No, I mean, I hear what you're saying, and we kind of touched on this yesterday when we spoke about, there was a bill about removing certain traffic offenses because the over-policing of certain demographics. And, part of that conversation was, and I thought it was a very good conversation, was about the other part of communities of color having suffered higher levels of violent crime. And I think that's a statistic that we don't, so when there's higher crime in these areas, there's going to be the police presence in those areas that's going to try to stifle that. So the recipe of all these things, I just keep seeing us trying to water down and take away more laws, and then we want to complain because it's always the police. The police are over-policing, the police are racist, the police are doing this, the police are doing that. And the reality is you're in those communities of color and we're having these violent crimes that require attention, and sometimes, and like the graphic I showed yesterday, there's guns relative to that. Showed it on a graph from the state police yesterday. High crime concentration, high gun seizure, high fatality rates of gun violence. So, I mean, this is a bigger discussion than just the needles. This is a discussion about, the whole re-engagement of the community with law enforcement, and not the parts of, well, law enforcement's bad, cops are bad, ACAB. If I see that, I see that painted all over the place. All cops are bad. All cops are bad. All cops are bad.
Yeah.
That's a mentality, and that's a part of the thing that we've got to do a better job of educating and reintegrating into the community to build that community trust. And all these things are doing is this isn't doing that. This is just enabling a certain mindset, a failing mindset, mind you, to allow people to feel empowered to have more stuff on them that is illegal. And these are the vessels in which it's ingested into the body. So if you're a diabetic and you say, look, I'm a T1D, you're a T1D. If you don't have a spoon that's got burn marks on it and residue with the needles and the other elements that are consistent with that, I think we've had, as you said, we've had different experiences. I just don't understand. I just don't like the continued, well, it's because of the police, over-policing. I mean, it's just the numbers are way different than what a lot of people would see. So I appreciate you.
I really appreciate you naming, like, I'm a harm reductionist, right? And I meet people where they're at. That's what my job is. And so my job is to meet not just people who use drugs, but it's to meet police officers where they're at as well, right? It doesn't really matter how I feel about police and policing and all of that jazz. What really matters is that I'm talking about participants in their experience and the fact that this is like a law, obviously. And so the way that they're interacting in this, like the way that they're being interacted with is from law enforcement. And so that's why, unfortunately, I'm talking about it.
I get it.
But the other piece is that, the syringe service programs are put into place in communities because of the statistics that have come out about the reduction of HIV, the reduction of Hep C, the fact that people receive more resources to treatment and to housing and to all these other things that kind of what you named is like, this isn't just everything touches something, right? Sure. And so it's like the vans and the buses and all of that stuff are put there in order to help people that are already using, that are already doing it in a way that might not be as safe as we would want, right? Some people don't want people to use drugs at all. I see that, I respect that. I also, I see people use drugs, I just want to make sure they're safe. And so those buses are there in order to help them be safe and also help the community, help clean up, syringes and stuff like that.
And I'll finish with this. In my opinion, I think that any government that allows that and facilitates that should be held with contributory negligence, because people are still dying. We're not lowering the numbers. Nationwide, we're not lowering the numbers. We're just not. That's the reality of it.
We just did this year, but I hear what you're saying, and if you want to, yeah,
we went from 100, we're over 100,000 still. We were 10 years ago. You said 50,000, or someone said 50,000.
We just heard the statistic of it being lowered from Yeah.
All right.
Through education and other components, I would like to think, not the decriminalization of.
We do have the opportunity to do the education. That's another part of syringe service programs.
Thank you.
All right, thank you very much, Senator Folden. Senator Amuse.
Thank you very much for coming down, and thank you for sharing your testimony. And I agree with my colleague on much of what he said, but I also want to make clear that there is a difference in experiences that in poor neighborhoods, whether white or black, but predominantly black. In a rich neighborhood, nobody's getting arrested for having an air freshener in their car. Nobody's going to get a busted head for having a busted taillight. The reality is these things happen, and we want to stop it from happening. So I want to thank you for your testimony on this bill, but just and until the day comes when our experiences are not as blatantly different because of the color of our skin. Until that day comes, there will always be perceived or real at times, and the statistics will show it, that we have a real problem that we want to deal with, and I think that's what this bill does. Okay, thank you.
Yep, thank you. Thank you for naming and highlighting that as well.
Thank you.
Awesome. Thank you, Senator Muse. Further questions from the committee? All right, seeing none, thank you very much. Yeah, all right, that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. And Merritt Williamson, please, welcome back.
Good afternoon, Chairman Smith and members of the committee. My name is Moreau Williamson, and I'm Assistant State's Attorney. I'm representing the Maryland State's Attorneys Association this afternoon. I've been a prosecutor for 17 years, and I've focused on felony narcotics cases for the past 10 years. I do agree with a couple of the points in SB 370. I do agree that the penalties should be reduced to be brought in line with the penalties for simple possession of a controlled dangerous substance. This is similar to what HB 260 seeks to achieve, and the MSAA does support that bill with a limited amendment. I also agree that striking the word administer from 56220 makes sense based on the intent of that particular statute. However, items associated with the use of fentanyl, heroin, and cocaine should not be decriminalized. Items such as needles and pipes. These items are part and parcel to the use of controlled dangerous substances, and the tools that are used to ingest these dangerous substances should not be decriminalized. Addiction destroys families and lives. Decriminalizing these items only limits the ability of law enforcement to address drug use in our state and to intervene and connect those struggling with addiction to treatment. We have excellent sentencing alternatives in the state. We have the 8507 program. We have excellent drug courts across the state. We have options in probation. There's also options not to prosecute the case at all, but a continuance or a STET or some sort of alternative like that to help that person get into treatment. We are in the middle of an opioid crisis. We should not be decriminalizing the tools that are used to bring about death and overdoses in our state. Thank you, and I welcome any questions.
So I'll be honest with you, I fully understand why we prosecute people to be using drugs. I've never understood why we're criminalizing the possession of things like syringes, which can be used for purposes that are not illegal, or measuring spoons and things like that, calling them drug paraphernalia. Why don't you think that merely criminalizing the use of the drugs is sufficient, and that we have to also criminalize the fact that someone is in possession of something which could be used to assist in using the drugs?
Well, someone is not going to be prosecuted for simply possessing a measuring spoon, to your point, and to the testimony before. Someone would be prosecuted for possessing a spoon, as Senator Holden alluded to, if it was burnt or it had residue. Someone might be prosecuted for having a measuring spoon if, when the police execute a search warrant and they find someone cooking up crack cocaine or meth or something like that in their house or their basement. These are items that are part and parcel to the manufacturing of a controlled dangerous substance or an item that is used to introduce or ingest these items into the human body. Mr. Cole said before, when there's smoke, there's fire. The police might find paraphernalia that might lead to more controlled dangerous substances. And if someone is found with just perhaps a burnt spoon or a syringe that is associated with drug use, that's an opportunity for the judicial system, the justice system, to get involved in that point for that person to help that person get into treatment. I've heard many times, sometimes people need what's called a nudge from a judge that gets them into the rooms of recovery, that gives them the idea of recovery. Maybe it doesn't stick immediately. Maybe someone has to go to recovery meetings or something like that as part of probation, and it doesn't stick right away, but the saying goes, if you go to a barbershop enough, at some point you'll get a haircut. We hope that at some point that message will sink in.
Okay, thank you for your answer.
All right, further questions from the committee? All right, seeing none, thank you very much. With that, that'll conclude the testimony in the hearing for Senate Bill 370. We'll now move on to Senator Love with Senate Bill 349.
Good afternoon, everyone. Mr. Chair, Vice Chair, honored colleagues. For the record, Sarah Love here to here to present SB 349, stopping the practice of placing a lien on someone's primary residence for medical debt. I don't think I need to explain to this committee what a problem medical debt is for people in our state and in our country. Emergencies happen, medical bills come in, and they come in, and they come in, and the debt accrues. Sometimes that debt results in people losing their houses, and to me, that is unconscionable. Several years ago, the Senate passed unanimously and the General Assembly passed legislation to stop the practice of putting a lien on someone's home for medical debt incurred from hospitals. This bill addresses non-hospitals. 44% of medical debt comes from non-hospitals. So, when we talk about non-hospitals, we're talking about private practices, dental care, long-term medical care, that sort of thing. Couple of notes I want to add. One, Senator West, when this bill came over from the House last year, you had a question regarding whether it would put a problem for a title searcher. And so we've gotten a letter from the Maryland Land Title Association. They've seen the bill. They take no position on it because it doesn't affect them. So I hope that allays that concern of yours. In addition, you should have an amendment in your packet relating to the definition. This was something that the Office of the Attorney General picked up on. So we have a sponsor amendment there. I would just close my panel, our experts, they'll talk a little bit more in detail about the legislation, but I just want to say that not only would this bill protect people from losing their home from foreclosure, but also from losing the ability to access the equity in their home. For many people, their home is their primary asset, and we don't want them to lose that as a result of medical debt. So with that, I ask for a favorable report, and I turn it over to my panelists.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Ernice Williams, and I'm here testifying on behalf of the Health, Education, and Advocacy Unit in support of Senate Bill 349. This bill will protect Marylanders from losing their primary homes due to unavoidable, unplanned, and involuntary medical debt. The Attorney General believes that no Marylander should be forced to liquidate their homes to pay for health care. According to a poll done in 2022 by the Kaiser Family Foundation, it was found that over 100 million people in the U.S. have some form of medical debt, and over half of them owe over $10,000. Accidents and illnesses happen every single day, and we never know when they're going to happen to us. Yet the Kaiser poll revealed that most of the people who are carrying this medical debt are those who are already marginalized, those who are Black and Hispanic, those who suffer from chronic illness, and those who are already low income. Even people who have health insurance, which the majority of people do in this country, they experience crushing medical debt. Those high deductibles, out-of-pocket costs, sometimes their insurance doesn't cover the care that they need, as well as the lack of transparency in healthcare leads to unexpected bills and costs. We suggest that requiring Marylanders to relinquish their homes in satisfaction of medical debt that they largely have no control over is against our state's values. We urge the committee to join the Office of the Attorney General in supporting this bill and protecting Marylanders and their homes. Thank you.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Marceline White, and I'm the Executive Director of Economic Action Maryland Fund. Economic Action is a statewide organization that works on economic rights, equity, and housing justice through research, education, advocacy, and direct service. Our direct service programs touch every county in the state, and we are here in strong support of Senate Bill 349, and thanks, Senator Love, for bringing it. A couple of points. Why is this bill needed? As you heard, 14% of Maryland households have medical debt that they cannot repay, and of those, 23% of those are Black-led households. So this has a disparate impact. As you heard, 44% of the debt is from outpatient services. This bill simply says that you should protect a patient's home from medical debt by prohibiting the use of a lien for medical debt. Home liens can harm patients' wealth, negatively impact a household's credit score, so they can't borrow more money, which creates a vicious cycle. It also can inhibit their ability to refinance, lower their wages, and pay back a provider. And because medical debt lawsuits disproportionately have been concentrated in Black and brown communities, it could have a disparate racial impact as well. This expands access to health care, reduces onerous excessive collection actions, and it would allow us to join 11 other states and territories that already prohibit liens on homes for medical debt, which have had no negative consequences for the healthcare providers in question. So for all of these reasons, we urge a favorable report on Senate Bill 349, and I'm happy to take questions.
Thank you, Mr. Chair. Thank you, Senator, for bringing this bill. So somebody had said that the person who has this debt largely has no control of the debt.
I think that's right. When you think about medical debt, you don't choose, you can't shop around. You're trying to take care of either an urgent dental situation or you need rehab, something like that for physical therapy, something like that. It's not like you're choosing to become ill.
Yeah, so these companies that are providing a medical service, do they largely control who's going to pay and who's not going to pay?
Well, I think what's important to know is there are still many ways that people can collect on the debt. That's a great question. Even if this bill passes, and we hope it does, certainly, they can still pursue wage garnishment and bank account garnishment to collect on these debts. So we're simply saying that the home should be protected, somebody's primary residence. So there are still other ways, and most debt collectors use wage garnishment first and then bank accounts when they collect.
So is there anything in this bill that while it doesn't force, is there any way that the medical debt, and I don't know if this is a vehicle that can be created or is created in other states, but is there a way that almost like a holding pattern, so the person decides to sell that asset of their own free choice, and there's a way that the medical debt then is tied to. Something similar to water bills, when we can't foreclose on certain jurisdictions, you can't foreclose on somebody because of past water due, but when you do sell that, that actually has to be paid.
I think I am not the lawyer in here, so I may defer to legal experts on this, but my understanding, though, is when you have a lien on the home, the problem is just having the lien itself on the home affects your access to credit and affects your ability to borrow. So I'm not sure if there would be a way to not place a lien on the home and then have them pay later on. I will defer to legal experts on that piece.
Not being an attorney either,
yeah.
And I tend to believe on JPR that it's actually a good thing.
Yeah.
But if we can do this when it comes to government doing water bills, I think that may be a thing. And I'm just going to, I clearly don't understand the impact of the pigment of somebody's skin, if they can afford medical debt or not. Medical debt doesn't pick pigment of skin. And so I don't understand why that is part of the testimony, because it doesn't matter. If you have medical debt, you shouldn't be forced to sell your house. I get that.
Yep.
But why do we keep on hinting upon that?
I think you're 100% right that everybody who has medical debt should be able to protect their home. We completely agree. The point I was trying to make is that when you look at medical debt lawsuits and where they have been pursued for medical debt, those have been more in majority Black and brown communities. That's all, just from a data perspective. If you're looking at where they've been suing, it's just happens to be in those communities. But everyone of course, who has medical debt should be able to protect their
would be
homes. And it
interesting.
affects all communities, across the state.
It would be interesting to see what that data drilled down would be.
I can show you a paper that looked at the lawsuits from hospital debt, and we can,
That would be great if you could get that to me.
Yep.
I'm not, anyhow, thank you.
Yeah,
Thank you, Mr.
absolutely.
Chair.
Thank you, Mr. Chair. My questions, I guess, are for the sponsor of the bill. Thank you very much for talking to the title insurance companies. That was a concern last year. But I think the bill itself continues to have some trouble. I'd like to get this bill enacted this year, but I think we need to get it enacted correctly. So, for example, medical debt is, excuse me, where is it? It means debt incurred due to a medication, procedure, or service. So if you had if a credit card company were to sue a consumer and included in the long list of items charged to the credit card were aspirin at the local drugstore, bandages, trips to restaurants, et cetera, that lawsuit wouldn't be broken down into medical components and non-medical components. So I'm not sure how that lawsuit would be covered by your term medical debt. Do you have an answer to how we would handle that?
So 2 answers. One is that you raise a really interesting question. Well, actually, before that, so point 5 of my answer is I'm glad that you want to get this through, and I am happy to work with you and work on language.
We may need a work group to
absolutely
tease out the issues and fix them.
And I agree that the issue of credit cards brings up something that we do need to work on. And we are talking with the opposition to try to work through some language issues to try to make sure that we're getting it right. I'll leave it at that. And then I believe council wanted to answer part of your question as well.
So the language of the bill addresses all medical debt, which we would interpret to include debt charged to a credit card offered only specifically for the payment of medicine, medical procedures and services, products, or devices. So we're talking about medical debt specifically for those things.
So last December, my wife had a medical incident, and she had to be flown by helicopter from Rehoboth Beach up to Wilmington. And then we got a bill from the local emergencies organization that handled getting her to the helicopter, another bill from the hospital, long itemization lists. And a lot of the things on those lists were certainly related to her medical care, but there were things that arguably were not. They were there because she was in the hospital, but they weren't directly related to her medical care. So that's the sort of thing I'm worried about here. The definition of medical care in the bill may be too broad, and I'm assuming you'd be willing to work to try to narrow the definition in a way which would limit it to medical care. The second question I have is relates to what the clerk is going to do in the court, because it says the clerk, where does it say? It says the lien. No. Hold it. I'll find it. I had it a minute ago. A lien. There we go. A lien on an owner-occupied residential property may not be created by contractor as a result of a breach of contract for the payment of medical debt. And it talks about what kind of information has to go in the complaint. So in order to make sure the lien didn't relate to medical debt, I'm assuming that the clerk's office is going to have to go back to the original complaint. And this bill says that the complaint shall indicate whether the judgment is sought for medical debt. So again, if the complaint is sought for lots of things, lots of unpaid debts, some of which are medical and some of which are not, I think we need to figure out how we divide them up so that the clerk knows the lien can be entered for the non-medical components of the judgment, but not for the medical components. Do you see what I'm saying?
I do. Can I go back to the first question or the first statement you had when you were referring to all of the care and services that your wife received while she was, being cared for. Anything that happened while she was receiving care, whether it was specifically related to her getting better or whatever treatments that she was receiving. I guess I don't really have enough details to kind of review her bill to say this was health care or this wasn't. But if it's related to her health and related to the reason why she was in the hospital, that would be considered medical debt.
Okay, that makes sense. Maybe we should make that clear in the bill.
Okay, and then Marceline's going to answer the second half of your question about the clerk and the lien.
Sure.
Yes.
Thank you for the question. I know this came up last year as well, a little bit, and I know that Delegate Embry worked with the courts in the interim. I was part of the work group, so were folks from legal aid, so was Ms. Williams' predecessor at HEAU. My understanding is that there would be simply a checkoff, like one additional checkoff form that somebody would attest that it's medical debt. The creditor would determine it was medical debt. And that seemed to be sufficient for the courts, and it seemed to resolve their concerns.
Okay, well, my concern was that the same lawsuit would involve unpaid medical debt and unpaid non-medical debt. Mm-hmm. And then the question is how we deal with that.
I think the response was that the onus is on the creditors to tease out what part of it is medical debt. But so
I'm
depending
with the clerk. The clerks tend to be
Yep.
In my experience, clerks tend to be functionaries, mm-hmm. and they check boxes.
Yep.
And they're not engaged customarily in exercising discretion. So if there's a judgment entered in a courtroom and the court judgment comes down to the clerk's office, right. How is the clerk going to docket that judgment? So the clerk has to have an easy way of determining whether this judgment is only for medical debt, only for non-medical debt, or for some mixture of the two. And if it's the latter, how does the clerk deal with the judgment? That's the question.
Yep. My understanding is there is going to be a form, and I think I can't answer how the clerks are dealing with it. I know that the courts felt like it was sufficient and it responded. But
I'm sure we can work this out.
Yep, absolutely.
Thanks.
Thank you, Mr. Chairman. Thank you to the sponsor of the bill. My question is for Ms. Williams with the Health Education and Advocacy Unit at the AG's office. Mm-hmm. It's my understanding that the AG's office is the agency that enforces these sorts of liens. Is there a unit there at the AG's office that places these liens? I thought they're a part of what you guys do in Medicaid was also enforcing and collecting and initiating these liens.
I'm really new, so that is a little beyond what I can speak to today. I can get that information back to you and kind of detail out what our process is. But I think this is more of a private action versus something that we're enforcing, but I'll clarify. Sure.
And as you clarified that, what I'm looking to understand is if there's ways that our AG, if they are in the practice of it, could discontinue the practice of it without legislation, or if it is absolutely necessary that we spell out that the components of the bill. I wasn't seeing something that affirmatively placed this duty on them where they had to engage in this practice. So I was just trying to figure out if there were options that were available under what we have existing, or if it's absolutely necessary to say, these additional measures must be in place.
Senator.
One thing that relates to that and may answer part of your question. In researching for this bill, one thing I learned is that when a money judgment is entered, a lien is automatically placed. So it's not the Attorney General's office that is seeking that lien and putting it on. It's an automatic placement on your primary residence, or actually on any property you have in the jurisdiction.
Thank you for the clarity, Senator.
Sure.
Thank you. Thank you, Mr. Chair.
Yes, thank you, Mr. Chairman. Thank you for bringing the bill. Just a little follow-up question. I'm sorry, I didn't catch your name. You testified that there are 11 other states that have something similar. So I'm wondering if this bill is modeled after their language. And secondarily, you indicated there was no adverse impact on healthcare providers. So I'm hoping you can provide some additional information on that. And here's why I'm asking. So in Maryland, we're sort of an all-payer system, right? So rates are set based on a multitude of factors, but it's a sort of a global perspective, including uncompensated care. And Maryland also has a remarkable, and we're the only state that has a Medicaid waiver, which deals with bringing down the cost of healthcare delivery. So what I'm while I'm very sympathetic to, trying to avoid liens on people's homes, I want to make sure that Maryland is very cognizant of, and each and any way we might be eroding our status as the only state that has a waiver, and be mindful of the idea that this could be absorbed across the system, and yet it could also raise rates. That's a lot coming at you, so it's okay if you don't want to bring. But if you could speak to it just a little bit, that would be helpful.
I can start and do a little bit.
All right.
I completely appreciate, I'm going to go backwards a little bit. I completely appreciate your concern about our global model and the system we have for uncompensated care. Just to clarify, that's for our hospital system and for our hospital medical debt. And we've already passed legislation in Maryland banning liens on homes for hospital medical debt. This bill pertains specifically to non-hospital medical debt. So like a dentist, or if you're going to physical therapy, it's that kind of debt. So
very good.
We're kind of exporting what we've already done in the hospital system to other kinds of healthcare providers. In terms of what other states have done, so like New York, for example, has banned liens on homes for medical debt entirely. They've also banned garnishments for non-hospital medical debt entirely. So this is a much more modest approach than what New York and some of California has done and some of the other states have done. So we're trying to really recognize that Maryland has been a leader in protecting patients, but we also want to make sure that we're not, we're taking it step by step, and the liens, again, are the thing that are really debt collectors are least likely to go after. They attach wages first, then they attach bank accounts, and then they do the liens. So we thought this was the first place to start. And again, because we know in Maryland with the cost of buying a home and the cost of staying in a home, that if you lose your home, for a lot of our older adults and a lot of our working families, they would have a very difficult time getting another home if they lose the home or they lose the equity. So that was kind of that.
That's very helpful. Could you address the statement you made, though, about no adverse impact on healthcare providers? So now that I understand, we've already done this for hospitals, which sort of pulls out my concerns about hospital rates and uncompensated care. What data do you have? And you can follow up, just give this to me about it not having adverse impact on healthcare providers. And one of the things I'm worried about is whether or not, providers indirectly start not treating patients that they're worried about and other unintended consequences. So could you speak to that?
Absolutely. So this is from, I work in a confederation and coalition with other state advocates, and the states that have passed this have not seen, dentists or anyone closing shop, certainly not because of this, or certainly not saying it because of this. So I will say that it's from talking to advocates and saying what is happening in your state, because again, we've been very cognizant that we don't want to harm, small businesses, small healthcare providers, et cetera, but they're not seeing that in other places that have had this in place for a couple of years.
Okay. And then it sounds like what you said a little bit earlier was sort of this is the mechanism of last resort.
Yes.
Right? So that probably means there's a lot of frustration all around, including to the provider, right? The provider's frustrated. They're not getting paid back either. So do you have data about if we pull this option off the table, is there an alternative to getting someone to pay this money? I just don't know how effective liens are. I don't know if it's so shockingly awful that it's true that people do pay up, but at what price to their security and home? So we're losing an effective tool to getting paid, but trying to balance it with losing at home. Or whether or not the other alternative, wage garnishment, and I don't know what the other option was, but whatever the other option.
Bank garnishment.
Yeah. So have they?
I mean, I'm not a member of the creditors board. Like, I'm not a lawyer, so I don't want to speak fully on behalf of them. But I can tell you from work we've done in other issues, they always say that they go after wage garnishment first because it's easy to do. You have ADP, you have these other places. It's very easy to just attach a garnishment to the wages. Secondarily, they go after the bank account because again, there are easy ways to find how much money you have in your bank. And this, we've done some work to protect the last $500, but those are the first two options. This is like their third option. So that's why we thought it was better to start with this one. And also because, again, the primary residence is so integral to individuals, communities, neighborhoods.
And then I don't know if this was already asked and answered. It might be to the bill sponsor, and it sort of dovetails with Senator West's questions. There is some, not so much opposition, but opposition as the bill is drafted because of the definition of medical debt. And I'm sure the bill sponsor is probably aware of that. It seemed like they had a good argument for why maybe we would adjust that medical debt definition to be more in compliance with federal understanding and or, that consumer group that's referenced in here. Did you read this, and are you comfortable working with those issues and defining medical debt a little more in line with what existing law elsewhere?
I did read that. We just became aware of their opposition a couple of days ago, so I am talking with them. We are working with them to try to figure out a path forward.
And my last question is just about there's a penalty in here for if a lien is actually created, or at least the option. And I don't see any out in terms, there is a discretion here, but I can imagine these could be done erroneously given what Senator West was asking and other factors. So is that a standard language in there that, I'm certainly fine with the idea that if they are inadvertently imposed, they should be removed, and perhaps the cost of removal should be borne by the party that inadvertently placed the lien. But I feel like there are a lot of players in the lien creation and in imposition, and I don't know if we should be, allowing for people to sue them for economic damages. So where's your thought there? Is that standard in other states?
So I haven't looked at other states specifically related to the damages. I think when this issue came up last year, one of the senators was discussing how healthcare providers, they don't have to go through as many steps as other lenders to put a lien on someone's home, whereas like mortgage companies have to prove so much more if they're going to put a lien on someone's home. And there are other companies that have to do a lot more work in order to prove that this is the right person. They do actually owe this money. The service was provided, but healthcare providers only have to provide a bill in order for them to be able to say that this consumer owes and now that we're going to put a lien on their home. And so I think that's why we wanted to make sure that that language was there so that people wouldn't say, oh, you owe me, $2,000 for a service that they may not have received, and attempt to put a lien on a home.
So if you could follow up with me and let me know that's true, because I didn't know that, and just be open to the idea that I'm not sure that would be quite the way I would word this or have this in the bill, right? So thank you, Mr. Chairman.
Further questions from the committee? I share Senator West's sentiment that we get these types of bills like every couple of years or so, and like the disaggregation of debt for like collection purposes is always a big deal, and then the definition of medical debt. But you think about like superficial cosmetic surgery, for instance. You just what I call superficial cosmetic surgery. Just those types of things we have to address. But I don't think we're far. All right, thank you all very much. All right, we'll now hear from the opposition panel. We'll hear from Scott Peters and Ms. Jones.
Sure. Good afternoon, Mr. Chair, members of the committee. I'm Lisa Harris-Jones, and I'm here on behalf of PAR Group. PAR Group and their subsidiaries are in the business of their publicly traded company, and they purchase consumer portfolios of debt from large banks. So their opposition to this bill, it's not to the intent of the bill. It's very, very specific to what Senator James pointed out, to the definition of medical debt. And I think what's not being thought of is that you can go into Sam's Club and use your medical credit card, and you can purchase something completely related to a medical purpose. But you can also purchase bubblegum or a tire. There's several things that you can do with these credit cards, and there's no way for the financial institution of knowing what was medical debt and what was something completely unrelated. And to make it even harder, when it's purchased by an entity like the client that I represent, they clearly don't know what's medical debt and what's not. And so they are open to violating the law, arguably. And so what they have suggested, and I think you have their testimony, is to follow the Biden-Harris administration's Consumer Financial Protection Bureau's definition of medical debt. And you discuss, how do we figure out what the best definition is, but they already did that, in that they looked at the definition when they were trying to determine how medical debt should be defined when you're able to report it on a person's credit report. And this definitely came down in a ruling just in January of last year, and California actually uses the same definition. So what we're asking is we're fine with the bill, except for the definition. And with that, we ask for an unfavorable report unless you take our definition.
You got to reframe that. It's favorable with amendments, It's, there, yeah. All right. We'll hear for the rest.
Good afternoon, Mr. Chair, and Mr. Vice Chair, and members of the committee. My name is Scott Peters. I'm on the board of the Maryland, D.C. Creditors Bar Association. I have personally represented creditors for, I think it's over 22 years at this point. So a lot of the questions that the committee has already posed, you did a lot of my job for me. They were excellent questions. And I'm here simply because the definition is far too broad. And I understand Senator Love is aware of that, and we are working on, or I would like to work on, a definition. The simple definition would be medical debt defined as money owed to a medical service provider. And I believe in my written testimony there is some language, and I have also spoke with other stakeholders about the CFPB's definition, which I believe is used in California. All of those focus on money being owed to the medical service provider. I think Senator West was right on point, and one of the biggest concerns with the creditors bar is that this definition is so broad, it will encompass virtually anything, like cosmetic procedures, elective procedures, facelifts, whatever it may be. It will encompass all of that. And sometimes that debt is put on your credit card. So when I represent Bank of America on a credit card debt, $3,000 is for non-medical debt and $2,000 is for a facelift. I don't know if that's how much it costs, but just it's $2,000 for a facelift. Now, when we're filing the lawsuit, the bill is asking us to check a box to state whether this is medical or not. And when it's commingled, there's no way to determine that. And that creates a big problem. So simply stating that it's money owed to a medical service provider, I think would resolve the issue, at least from the Creditors Bar Association. And I think it would, I guess, create less issues for creditors in the future.
And thank you, Mr. Peters, for your testimony. Let me try to go a little bit of a different direction. Let's assume we could agree on the definition of medical debt. And therefore the debt entered as a judgment in the court records by the clerk reflects that some debt is medical and some's not. So what this says is that the medical debt would not constitute a lien on the property. Suppose we allow it to be a lien on the property, but we merely provide that the person who holds that judgment is not permitted to file a foreclosure case against the personal residence of the debtor. On the other hand, it would remain a lien, so if the debtor sells the property at some time down the road, first, of course, there's a list of priorities as to what happens when property is sold. The mortgage gets paid off first, taxes, property taxes get paid off. What's left is debt. Wouldn't it be appropriate to have medical debt be one of the things that's paid off from the proceeds of the sale of the property before the owner of the property gets what's left as a big check? It seems to me that that would not be inappropriate. If my wife goes to the hospital and incurs medical debt and it becomes a lien on our house, and then we sell the house, and we haven't paid the debt for whatever reason along the way, it makes sense to me that when we sell the house, from the proceeds after paying the mortgage and the property taxes, et cetera, proceeds, that debt for the medical expenses, along with all the other debt that is represented as liens on the property, should be paid before we get a check from the remaining proceeds of the house. Does that make sense to you?
Yes, and thank you for the question. It makes perfect sense. And that's how it is with non-medical debt right now. So a lien is simply, it just attaches to the house. A house is only sold if the creditor chooses to actually execute on that lien. So I will say, in my experience, I have never executed on a residential lien and started the process to sell a house. I don't believe most creditors do that. I think the proponents of this actually indicated it's the last remedy, and I personally have never done it. So the lien would still sit there. And like you said, if the house sells and there's a surplus, yes, it does make sense that a medical debt would be paid from any surplus before it would be paid to the homeowner. But that being said, the creditor's bar is not opposing the prohibition on creating a lien. We do think there's a problem with the mechanics of how you're going to stop the lien from being created. That is, in this state, Maryland Circuit Courts and the Baltimore City District Court are what's called the courts of record. That's where the records are kept. So if I obtain a judgment in the circuit court, it's automatically a lien. I don't know how the clerk or the court is going to stop that. And same thing with Baltimore City District Court. If I obtain a judgment in the district court for Baltimore City, it's automatically a lien. I don't know how that stops. Now, if you're getting a judgment in the district court other than Baltimore City, the creditor has to actually file a request to have that lien docketed in the circuit court. So there's a process, and I'm more concerned about the courts where liens are automatic. And that leads me to the enforcement provision, where it simply states if a lien is created, that I assume they're blaming the creditor for that lien being created, when I'm fairly confident, if this passes as is, that there will be circumstances where a lien is created and it will be through no fault of any client of mine. But under this statute, it says you're at fault. You're liable for damages. So I don't know how you fix that, but that's a concern for the creditor's bar as well.
Probably have a work group at some point, and maybe we'll pull you in to help us out.
Very well.
Thanks.
Thank you.
All right, further questions from the committee? Seeing none, thank you. All right, thank you both very much.
Thank you.
Thank you. With that, that'll conclude the hearing for Senate Bill 349. We'll now move on to Senator West with Senate Bill 286.
Good to see you again. Thank you, Mr. Chair. It's a pleasure to be with you to present Senate Bill 286. This is going to be probably the shortest bill hearing of the day. We only have one witness, and there's no opposition. Under current Maryland law, there are specific requirements for registering a domestic partnership or obtaining a marriage license. They include information like the full legal name, the address, the date of birth, the marital status, and so on. However, the domestic partnership statute in the Estates and Trusts article does not currently comply with federal law. 42 U.S.C. 666-13A requires states to collect the Social Security numbers of people applying for certain licenses, including marriage licenses. This bill, therefore, simply adds the reporting of both parties' Social Security numbers to their registration in these domestic partnership cases. These registrations are made with the Register of Wills. I asked and made sure that the Register of Wills does not make the Social Security information public. So it's not as if providing this information to the Register of Wills is going to make it available to anybody who wants to try to figure out what your Social Security number is and use that in some prejudicial way to affect your life. This is a minor change that will simply add another layer of verification to the registration process and will help to ensure that we do not lose federal funding for programs like temporary assistance for needy families. So I appreciate the committee's consideration of this bill. Alexi Burrell-Rode, who's the Register of Wills of Baltimore County, is with us to provide additional testimony.
Thank you, Senator West, for sponsoring this, and good afternoon to the committee members, chair and vice chair. My name is Alexis Burrell-Rode. I'm the Register of Wills for Baltimore County, and I'm here to in favor of Senate Bill 286. And I just wanted to add a little bit to what Senator West has already said. 42 U.S.C. 666 is a federal statute that is that was enacted to help with child support enforcement. So it's the requirement of statutory prescribed procedures to improve the effectiveness of child support enforcement. So the purpose behind requiring Social Security numbers when someone applies for a business license, a marriage license, any type of a fishing license is to collect the Social Security numbers of that person so child support enforcement can do a data match to see if those individuals owe child support. So right now, as Senator West said, our Maryland's domestic partnership statute does not require the collection of Social Security numbers. So we're just asking for this technical change to make that a requirement so that we can be sure we comply with federal law, and that the downside to non-compliance is perhaps a loss of TANF funds from the federal government. So there's a little carrot and stick for making sure we have this information. So if there's any questions, I'd be happily answer them.
All right, seeing no questions from the committee, thank you both very much.
Thank you so much.
Excellent. With that, that'll end the hearing for Senate Bill 286. We'll now move on to our final bill of the day, Senate Bill 356. Hey, how are you? How you been? Good, good. All right. Mr. Vice Chair, with your indulgence, I would bring up my panel. So for the record, Senate Bill, this is Senator Smith here to present Senate Bill 356. Now, we've seen this bill before. We had this bill in committee last year. It passed over from the House with bipartisan support. And if you look in the bill file, you'll see that there's a wide array of support for the bill from everyone from Free State all the way through to the state's attorneys, both of whom are here today to testify in favor of this bill. Now, I'll admit to you, when we first got this bill, I looked at, bipartisan support came over from the House. It's one page, very simple, straightforward. But I had some hesitancy in moving on it because of what was just facially in the bill. We're removing an offense that seemed to me to be something that would be, why would we do that? Why would we take this policy course? So I want to explain a little bit of the history and some context, and then also the practical application, which our state's attorney will speak more to in terms of how this actually works. And why my initial impression of the bill was wrong. And so before I dive in, I also want to say thank you to Senator Young from Frederick, who had this bill last year. I thought she provided a very lengthy and detailed testimony about the history. And then also Delegate Fair. He was very tenacious in his advocacy and in the House and then over here in the Senate. So look, the bill basically removes a section of the law that was enacted back in 1989, which was in the midst of the AIDS epidemic. And this piece of legislation targeted specifically HIV/AIDS and no other transmissible disease. And we'll have some witnesses that'll come up a little bit later to speak more to the context of when that piece of legislation was enacted in 1989. But essentially what this bill does is it removes a section of the code, Maryland Health General Code 18601.1, exposure of other individuals by an individual with human immunodeficiency virus. It removes that. And the practical application, though, is that anyone that engages in this activity can and will most likely be charged with one of two other offenses, reckless endangerment or assault in second degree, both of which carry higher sentences than this statute that we're seeking to repeal today. And so functionally, as you'll hear again from the state's attorneys, you're going to get higher penalties for this activity if you engage in this, and it'll be for all transmissible diseases, not just for HIV, therefore removing some of this antiquated and frankly tragic history from our statute, and then making for a better, I think, prosecutorial path forward for seeking justice for victims if this ever happens. So with that, Mr. Vice Chair and members of the committee, I'm going to pass it off to a person who's been interning in my office from the University of Maryland, a sophomore, Mays. They are here. They actually helped prepare the binder for this bill and has taken a very strong interest in this piece of legislation. So I want to just turn the podium over to them with your indulgence, Mr. Vice Chair, and give Mays an opportunity to take the podium and round out my testimony. Here.
I want to thank the chair, vice chair, and members of the committee for granting me this opportunity to speak before you today. Carlton R. Smith was a Black LGBTQ+ HIV/AIDS activist who lived in Baltimore for many years and is known for his role in advocating on behalf of LGBTQ+ and HIV-affected communities within the state of Maryland for decades. Carlton was a longtime HIV survivor himself who had contracted HIV in 1986 when he was just 21 years old. Carlton's diagnosis came during an era in the United States where severe inaction by the government and the medical industry was worsening an already unfortunate epidemic of HIV and AIDS within the American population. Carlton R. Smith dedicated his life for fighting for the rights and advancements of other marginalized communities, especially Black, LGBTQ+, and HIV-affected people like himself. Carlton co-founded and directed Black Equity Baltimore, where for over 20 years he led numerous events, rallies, and education programs that revolve around celebrating the lives and improving the lived experience of Black, same-gender loving people in Baltimore City. At Free State Justice in particular, Carlton is known for serving as a member of Free State's coalition to decriminalize HIV in Maryland, where he offered valuable insight and policy knowledge to coalition members regarding the fight to pass a bill that would repeal existing state laws that criminalize the transmission of HIV. Carlton served as a community participatory advisory board member at Johns Hopkins University Center for AIDS Research, was elected chairman of the Ryan White Planning Council, and was a proud deacon at the Unity Fellowship Church of Baltimore. Carlton R. Smith worked tirelessly on behalf of Marylanders affected by HIV, and we must honor his life and his dedication through the passage of Carlton R. Smith Act. The prohibition on transfer of human immunodeficiency virus passed almost 36 years ago, before the many significant scientific and medical breakthroughs regarding the human immunodeficiency virus. Not only does Section 18601.1 fail to accommodate these modern advances, but it has and is unfairly targeting a community that has already been through enough. On behalf of Carlton R. Smith and the community he fought for every day, I ask the committee for a favorable report. Thank you.
Thank you. Good afternoon. Chair Smith, thank you for bringing this forward. Vice Chair Wall-Striker and esteemed members of the Judicial Proceedings Committee. For the record, my name is Ronnie R. Taylor, and I serve as the Community Advocacy Manager at Free State Justice. I'm here today in strong support of Senate Bill 356, which seeks to repeal Maryland's outdated prohibition on the transfer of HIV. This is personal, and thank you so much for sharing that story about Carlton. For you all as committee members, I want you all to know I've had the honor and privilege of knowing Carlton for the last 15 years of my life. He is how I became dedicated to this issue. I personally brought him to Annapolis for a lot of the advocating that he did surrounding this piece of legislation. And so the only piece of we've worked really hard with our advocates and stakeholders, and the only change that we want to make to this bill, and there's been a change in position from some folks, and the only change we want to make is naming this bill after him to honor his life. As you heard, he was diagnosed in 1986 when he was a senior at Morgan State University. Devastating, because he's seen an entire legacy of people dying around him. And this was back then when it was known as GRID, gay-related immune deficiency. We are seeing today that this is no longer a 1986 gay man's disease. Our Williams Institute report, among some other data, shows that Black and brown women are primarily targeted and impacted by this legislation. They are the piece of representation missing from our data. And this bill will help us with access to treatment and testing, because if you folks fear that if I know, right, I won't move forward with testing and treatment. And we're seeing that there are some funding barriers surrounding testing, access to PrEP and PEP, which is post-exposure prophylactics. And so I stand before you all today and just ask for a favorable report. And I just say that I'm super passionate about this as someone who's HIV negative. However, we are all HIV possible. And so with that, thank you for your time.
Thank you, Mr. Chair, Mr. Vice Chair, esteemed committee members. Again, my name is Joyce King. I'm standing here on behalf of the Maryland States Attorneys Association. I'm Chief Counsel at the Frederick County State's Attorney's Office, and we were asking for a favorable report. And you know, as the co-chair for the MSAA Special Victims Committee, we did have at length discussion regarding this statute in the last couple of years, and there is, again, unanimous consent as to the repeal of this. We are able to proceed under the legal theories of second-degree assault and reckless endangerment. The MSAA confirmed with the Attorney General's office and received a legal opinion from them as well, and we agree with the health departments that not only is there no legal reason to single out HIV any longer in the statute, but it really does stand against public and health policy recommendations that exacerbate these disparities and, most importantly, discourage HIV testing. This law, as stated, hinges on outdated beliefs and routes and risks regarding HIV transmissions, and HIV is no longer a death sentence. It is now a chronic manageable disease, as with other sexually transmitted diseases, and there is no legal basis as to single it out. I am happy to elaborate any further if there's any further legal questions as to the proceeding under second-degree assault and reckless endangerment. And I will note, as the chair stated, not only are they higher penalties, but in actualities, because I have prosecuted this and have previously convicted people with this statute, is that it merges sentences anyway. So there really is no reason to, other than a public shaming.
Actually, not for the sponsor. I wanted to ask a question of the last witness, if I could. So I'm looking at the testimony of the University of Baltimore School of Law, the Human Trafficking Prevention Project, and I was taken by a sentence in the second paragraph. It said, data indicates it's primarily sex workers living with HIV who are criminalized under these laws. So please explain to me, if you would, why we should decriminalize this so that sex workers who have HIV can continue to pursue their trade and in the process possibly infect people who are unaware that they are engaging the services of a sex worker who has HIV.
I don't believe that we're encouraging or endorsing that. As I stated, we can still, if appropriate, proceed with other legal theories of prosecution if it's the intentional purpose of them to transmit that. So I believe that the testimony, I believe that's from Ms. Emerson from the Trafficking Task Force, is that the task force also has supported this in the past with regards to we want human trafficking victims to get the help that they need.
Well, I think the sex worker would tell you that it's not her intention to transmit the disease, but that she needs to make an income. And the fact that she has HIV and might transmit it should not stand in the way of her making an income, and that's why she wants to continue to ply her trade under the circumstances. So, should it be our public policy to enable people who have HIV to continue to possibly transmit the HIV to other people who engage the services of the sex worker?
I guess fundamentally I disagree that the repeal of this statute is somehow endorsing that or allowing that to continue. I believe, like I stated, I mean, the topic or the issue of sex workers and or whether they're voluntary or truly being trafficked, I think is another policy discussion that we are, as a human trafficking task force, approaching and trying to get to the causes and conditions of that. But this, with regards to this bill and this statute, I do not believe that this endorses sex workers or the proliferation of HIV at all. And to that point, with regards to reckless endangerment and whether or not they intend to, we can still proceed with reckless endangerment. If someone is HIV positive and engaging, I mean, and I hesitate to go this route because we would never do it this way, but theoretically, the legal standard for reckless endangerment is a lower standard, which doesn't require the intent that I'm trying to give someone HIV.
And along those lines, I'm assuming that if a sex worker intended to transmit the HIV to her clients, that she could be prosecuted.
Yes.
Under existing law.
Correct.
Thank you.
And pardon my ignorance, I was wondering why that is even in law for prosecution, period. If a person has COVID, have you ever prosecuted a person with COVID?
No, and that's exactly why we support the repeal of it, is because it is archaic. I believe that the creation of this was at a time when HIV was a death sentence, so they wanted to single it out, but that is no longer.
And measles, or parents who don't want their kids to be vaccinated?
Right.
No, you don't prosecute.
No, there's regulatory, I think, fine only under
But-
COMAR that we could in theory proceed, but we do not.
But that would almost be the same, I mean, when they go out, they do it intentionally. So why even, I mean, you might not be able to answer this, is that even in statute?
And I think that's exactly why we want to repeal it, because it was created at a time when it was
And it's
intended
no
to be
longer.
singled out.
Okay, thank you.
Thank you, and I appreciate getting more information, because I sort of had the same reaction you did, but I really just, when you learn something, you want to ask more questions. There were 146 cases, according to the fiscal note, in the last 20 years, and 14 convictions. I don't know if anybody knows about those cases, why those cases, and the reason I'm asking is I'm hearing what you're saying about, look, we can prosecute them under existing criminal law. So why would, so I want to know whether these cases represent an issue that maybe I'm not aware of and you aren't aware of, where this was really a necessary statute in some way, because I don't know why they just weren't, held accountable criminally for the existing laws that you're referencing now. Do you have any information about that?
Senator James, that's a really good question. And so what we have seen, again, from our amazing report with the Williams Institute, amongst some other resources in which we've been able to pull, and to Senator Muse's point, and I hate to be this person to kind of make everything about race, but historically this was on a docket to incriminate Black gay men. Let's just call it for what it is.
Black what?
Black gay men. This was used to stigmatize and incriminate Black gay men. However, we have seen that a lot of these cases, they're often used in revengeful situations. And so it's part of DV, relationships ending, and I'm not a lawyer, I'm currently in law school, but, intention, how that holds up in intent to court can be super vague.
And then my follow-up, so maybe we'd get a little more information if you can. I don't want anybody to, I'm just thinking maybe if the fiscal people could have gotten it and put it in a note, maybe somebody else could. But, and then I read, just want to hear you all respond to this. I guess it was the chiefs of police are talking about, unfortunately, I guess in prisons and detention centers and other situations, perhaps, maybe when law enforcement, I think it's correctional officers, they're saying we have this situation where there are inmates who fight us and there's a deliberate intention to, it may not be limited to AIDS or HIV, but, are deliberately trying to not only hurt us, but also infect us. And they were hoping that the bill should be amended to specify criminal charges for those who intentionally harm or threaten to harm individuals and officers by transferring an infectious disease, which really would be broader, it would get rid of the reference to HIV or AIDS. Are you all okay with that? Is that all right? Is that necessary? What are your thoughts?
Yeah, again, super, and I want to answer your question directly. However, one of the issues that I have with the prison system statement on it, again, this is the only infectious disease called out in criminal code. And so are we feeling that way about someone who may have genital herpes, which, which undergarments can be washed?
Their suggestion is to make it infectious diseases, so right?
All
So
of
I actually think it might be a fair request, Mr. Chairman. What do you think?
No, that was a policy call and it's a discussion we had. I actually remember a vivid conversation we had on a conference call because that's creating a separate offense, a new offense. And so what we came down to is, look, like the penalties for reckless endangerment and assault in the second degree are sufficient to meet and are easy, or what the state's attorneys will use to prosecute that activity. That's enough on the books as it is instead of creating a separate offense. You'll note that if you go back in the bill file, MCASA and I think the Attorney General had the same suggestion last year. They have altered their thinking on this.
Okay.
And this year are no longer moving forward in that same posture. I think we're all simpatico on the fact that reckless endangerment and second degree assault are sufficient to curtail that type of activity.
And the state's attorneys or whoever would prosecute these cases, well, we have trouble recruiting correctional officers. We have trouble keeping them. It's a tough, tough job.
No, absolutely.
The conduct that you and have you been vigilant?
Yeah, the conduct that you described, we would absolutely proceed on second degree assault, which is a 10-year penalty and a much higher penalty.
Very good. Thank you.
Mr. Chair. Thank you, Mr. Chair. Question for Mr. Chair. I have a chair question. So I just to understand the bill.
Yep.
Just want to make sure there aren't any unintentional consequences. Very, very long time ago, the Tuskegee Airmen were tested on syphilis. I just want to make sure that I don't believe this bill has anything to do with that, but it's not setting any kind of precedent allowing government to be able to do that in the past.
No, I mean,
or in the future, what they did in the past.
Thought very carefully of, I used the, I mean, a couple of us were on Judiciary back in the House, at least the Vice Chair and I were. And there were a couple of, litmus tests for a piece of legislation is, does the bill address a Maryland problem? Does it solve that problem? And then 3, what are the unintended consequences? And so I thought very carefully about all of the potential unintended consequences, mostly along the same lines of what Senator West and Senator James were talking about in terms of the prosecution and the penalties that are available for this. There's just really no need for the statute, as the state's attorneys have told unanimously have come forward in support of this bill. And it is my belief, and I'll put this on record, I don't think there are any unintended consequences that would permit or allow for government testing or anything of that sort. But I appreciate the question.
It was posed to me and it needed to be asked. So
no, I hear you. Thank you for the question.
Thank you, Mr. Chair. So I'm going to speak from an experience that I had, and the intent was entirely malicious and purposeful, and I want to know how this changes that. So during an incident, suspect goes to bite me. They bite my hand, break the skin, looks up at me and laughs, says I'm HIV positive. The intent was there. I have to go through a series of follow-up blood tests as a result of that. It was obviously an assault because of the bite, but in current law, it would be an assault and then you could add discharge. So it'd be separate because he had an intent to transfer that by breaking the skin. Is that not correct and currently?
I'll let the state attorney do this, but it's a lesser included offense. So
yeah, no, that's fine. Okay. Joyce can come up.
Okay. Yeah. You're gonna.
I wasn't trying to
get a higher penalty.
You're
that's what I was looking at.
Right, you're not. They merge and it's a lesser included because it's the same conduct. The unlawful touching is the bite.
So the question becomes, in the incidents of within prisons or in a relationship where the subject learns that they're HIV positive, they go and knowingly, after being made aware of this, without making the other aware, engage in intercourse and do it in a way that would be vengeful, I guess is the right way to say it.
It's still a second degree assault.
And so it's a second-degree assault
Either way, because
because the language of second-degree assault is any unwanted touching or,
Even though you're consenting to the sexual conduct, you're not consenting to the transmission.
but that's what I'm saying. So, but clarify for me in second-degree assault where, I mean, it's a pretty simple law. It's not like a big thing. So I'm curious as to how it would fall in second-degree assault where the structure is any unwanted touching, where you're saying that touching was wanted,
well, it's not
but
because
the
the consent.
transmission of the fluids that infected the person was not the intent.
Correct. Well, the intent
Of the
is the
victim.
contact. So for second-degree assault, the state has to prove that the individual caused an offensive contact with physical harm, that the contact was a result of intentional or reckless act and was not accidental, and the contact was not consented to or legally justified. So in that situation, while the contact, and we discussed this with regard.
Contact is legally
Well, we
consented
discussed
to.
this with regard to consent last year. So if it's under the guise of deception, that is not consent. So if the person would have known that you were HIV positive, I would not have consented to that contact.
Let me give you, there's a case, I'll pull this for you and give it to you. It gives a good example. So husband and wife have sexual intercourse. Husband gives the wife a disease. And so she successfully got him on the second degree because while the sexual activity was consented to, the transmission of the STD was not. And so that was enough to get them. So I'll pull the case in.
So I just think it's different than what, I understand where my good friend here was going with, COVID and things like that, but there's a difference between COVID and you're not knowing the transmission is occurring versus the actual malicious act and intent with that intended outcome. That's different than the examples he gave. So I just want to be clear on that. So, okay, I appreciate it. Thank you.
Still go with reckless, which is doesn't inquire the intent, but.
Thank you. My question is for Ms. King as well. Different than the senator's questions, but a little bit related. And obviously, I support the bill, empathetic with its goals. I don't understand how you landed on second-degree assault instead of first-degree assault, given the nature of the disease. And traditionally, we define first-degree assault as damage to organs or limbs. Blood is an organ. Like, walk me through how you landed on second degree and not first degree.
And that's a great question. With regards to the case that I personally handled, we went through this conversation with the health department, and it's not life-threatening. A lot of times it depends on the viral load and being able to prove as to what level the viral loads are, what effect that would have on the individual. We believed that it was on sounder legal ground to proceed on second-degree assault.
Sandy.
If you were to stab me in the shoulder, that wouldn't be life-threatening, but it would still count as a first-degree assault. You wouldn't charge a
Right. I
stabbing
think it
as
was
a
the nuance of deliberating whether the harm was going to be, I mean, this was just, when we were proceeding on our case, we weighed out the victim's wishes as well as the discussion, the public policy discussion as to this, and where we landed is because of how treatable it was and how minimal for our victims, the contact that, that's why we landed on a second degree.
For it to be treatable, the victim would have to be on medication for the duration of their life.
Correct.
Is that right?
Correct.
And like, if we're talking about like this, just to be clear, I don't believe these behaviors are analogous. I'm just trying to understand what you normally charge under first degree. If you were to charge something under first degree assault, it wouldn't be relevant, particularly that the person had wound care or, that it was a treatable stab wound versus a more challenging stab wound to treat. The treatability of the wound is not defining in the charge the damage that is done under first degree assault, I guess.
No, absolutely. I mean, I think legally we could proceed with it. I mean, I'm not saying that we couldn't, but in our state's attorney's offices and SVU prosecutors, we have historically gone with second degree. just as a charging decision. But I think there would be circumstances if there was a high viral load or if the impact on the victim was substantial that we could proceed under first degree. I'm not saying that you couldn't.
Okay, not a challenge to the bill. I just wanted to tease out what your thinking was and
Yeah.
why you landed. Okay, thank you. Any other questions for the sponsor or this panel? Thank you so much, Senator. And that's our last bill of today. We are adjourned.